So any page mentions call करो.
Supplemental list, page 1, Toto, 9.
My lord, item 8, my lord.
1 second. Just give me a second. Yes, item 8.
My lord, kindly list it after vacation, my lord.
No. Disposed of. After status is obtained, I cannot keep it pending. Disposed of.
I'll
Counsel for
present
the
some
petitioner.
citation, my lord.
Citation
I'll
you
present
cite before the higher court or the trial court.
the higher court citation. I'll present here, my lord.
You have to challenge this to cite that. You have to challenge the order.
But
I cannot.
I'm not. I have not prepared that one. Kindly list it after
I am
vacation.
prepared. I am prepared. The matter was heard at length on Mr. Manoj Kumar Naik for the petitioner. The matter was heard at length on 14/5/2026. देखो आपण रिपीट करो तो ऑर्डर डेटेड 14/5/26 पारा 1 2 3 4. Three. Then 5. One two पर लिखिए. One पर लिखिए. 1 पर 4. 1 then 4. After hearing the learned counsel for the petitioner on 14/5/2026, the following order was passed. Para 2, 3. 2, 3 and 5. Thereafter, the matter was listed on 20/5/2026 with report of the Honorable the learned Additional Senior Civil Judge Berhampur Punjab dated 15/5/2026, which is available in the paperless court, which is available in the paperless brief, and the learned counsel for the petitioner was apprised of the same. He sought for adjournment and accordingly the matter was adjourned to 21/5/2026. On 21/5/2026, the matter having been listed for fresh admission, the matter it is mentioned at the beginning of the day's proceeding by the learned counsel for the petitioner. He states that he will cite some decisions of the Honorable Apex Court, and the matter may be adjourned. The report furnished by the learned court in season of the matter is reproduced herein. Flag B, information relating to CS number 329 of 2021. Scanned and reproduced. Scan कर दे. Perusal of the report indicates that the defendant number 1, who is the petitioner herein, has appeared on 95 dates through her counsel, and the matter has proceeded. She appeared on 5/11/2021, filed a written statement on 20/12/2021, and the matter was transferred by the earlier direction. Who had filed the earlier transfer application, Mr. Naik?
In the court below, we are the defendant, my lord.
Who had filed the transfer application earlier?
We only.
The petitioner had earlier sought for transfer of the matter, which was transferred to the learned court at her instance and convenience, exercising jurisdiction under section 24 of the CPC. The petition name and number?
Manoranjita Behera.
से जो पिटिशन नेम टा पिटिशन रा सॉरी पार्टी ना से पिटिशन रा केस नंबर टा जोटा ट्रांसफर हेतले
Transfer petition
however the learned counsel for the
ERP
petitioner is
34 by
again
ERP 34 by 2022.
TRPC 34 by 2022. The defendant has to appear for examination and cross-examination and closure of the evidence. This present application is clearly a strategy not to appear before the trial court after appearing for 95 times. Stop. It is further indicated by the learned court, learned additional senior civil judge Hon'Ble, that she can appear by using ICT facility if it is permissible under the relevant rules. In view of the above discussions, this court is not inclined to direct transfer of the application as sought for by the petitioner after 5 years of trial, and it was transferred at her instance to the present court, that is First Additional Senior Civil Judge Barhampur. Court to transfer ହେଇଥିଲା sir?
Transfer ହେଇନି ବରହମପୁର ଟୁ ଭୁବନେଶ୍ୱର କୁ ପ୍ରେ କରିଥିଲି.
अरे आगो प्रेयर जोटा ग्रांट ହେଇଥିଲା 24 रे TRPC रे
सेम माय लॉर्ड बरहमपुर सीनियर डिवीजन सिविल जज टू भुवनेश्वर सीनियर डिवीजन सिविल जज
24 मसिया रे को कोर्ट रो कोठी प्रेयर करथिले ट्रांसफर
बरहमपुर सीनियर डिवीजन सिविल जज टू भुवनेश्वर सीनियर डिवीजन सिविल जज
सेटा कोन डिसमिस ହେଇଥିଲା 22 मसिया रे जो ऑर्डर ହେଇଥିଲା
देटा एलाउ ହେଇଥିଲା विथ VC रे ଦେଇଥିଲେ କିନ୍ତୁ ସେ ଆମକୁ ଏ ପର୍ଯ୍ୟନ୍ତ ଦେଇନାହାନ୍ତି VC फैसिलिटी
से जो पिटिशन टा को से प्रेयर कोन थिला से पिटिशन टा काढी देबी records of the TRPC are called for reference. Accordingly, the petition is dismissed. Yes.
Page 2, 10 to 20.
Keep on.
Page 3, 21. Page 4, 22 to 28. Page 5, 29 to 37.
My lord, item number 34, my lord.
Yes.
I am appealing with the petitioner, my lord. I have taken consent from Mr. Raut, may be taken up after vacation, my lord. Item 34.
34. Afterwards.
Who comes in? Satish sir.
So this
Interim to.
इतनी बड़ा कौन सा adjournment खेला ना कौन सा
Yes, my lord.
So this लेखन तो 34 the matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the petitioner. फिर ICT paragraph add करी उतरे बड़ा dispose of है ICT paragraph कुछ कर चुका हूँ हाँ अच्छी हो chance देवे ICT matter being in the list was mentioned by the learned counsel Deepak Rajan Sundar Rai for the petitioner, Mr. Gajendra Nath Raut for the opposite party. The matter being in the matter is listed for hearing under the heading so and so. It is mentioned by the learned counsel Mr. Sundar Rai for the petitioner and submits that he has obtained consent from the learned counsel for the opposite party and seeks for adjournment. Which order, sir? Sundar Rai co-order.
My lord,
Interim
my lord,
order.
19.6. My lord, interim order dated 19.6/2025, my lord. GR case has been stayed, my lord. Further proceeding in GR case now.
Order dated
19.
कौन था पर लिखी फिर इसको लास्ट लाइन
Submitted to the content person from the current council for the respective to 6. Adjournment.
6 for
6.
and 6 are adjourned. Accordingly, the matter is adjourned. The interim order dated 19/6/2025 shall continue till the next date of hearing.
Oblige, my lord.
Yes, please.
My lords, item number 33, my lords.
33, yes.
33 my lords, I am for the petitioner, my lords. My lords, I will file rejoinder today, my lords.
So
I am for the
you inform, you are for the
Lordship, I am for the opposite party.
33 টা adjourn कर दी.
Full council 27.
27
My
sir.
lords, interim order was there, my lords.
Interim order regarding?
Dated 24/7/2025, my lords.
No, because I am not touching any interim order.
My lords, to move adjournment application.
So, D. Barik, you want Mr. Barik?
My lords,
D. Barik for the petitioner. Mr. Ramdas Achari for the opposite party. The matter being listed for hearing under the heading for admission is mentioned by the learned counsel for the parties at the beginning of the day's proceeding. Stop. Adjournment is sought for. Accordingly, the matter shall be listed in the week commencing. Listed for admission in the week commencing 27/7/2026. The interim order dated 25/8/2025 is reiterated. Stop. Upon a prayer being made before the learned court in session of the matter, CMC case number 1409 of 2024 shall be adjourned to a date beyond 31/7/2026 as would be convenient to the learned court in session of the matter. Stop.
oblige, your lords.
Yes, next.
Yes, I
Item 27, madam.
27.
Yes, madam. In this case,
Yes, madam.
madam, state is to file the counter. Till date, the counter has not been filed.
State, who is appearing 27, Mr. Mahanti? Supreme Kumar Mahanti.
I think
Prabhu, madam.
Prabhu. So inform Prabhu.
Madam.
27 तारे डेट कर दियो तो
full council 27.
27/7.
Yes, madam. Oblige, madam.
Yes.
Page 6. 38 to 41.
On the list.
To be mentioned item 1.
Yes, Mr. Das, you could not obtain instruction?
Yes, my lord, I could.
Yes.
Now, the fact remains, my lord, your lordship wanted me to take instruction as to how much I can pay.
Not you, your client. Don't pay.
Yes, my lord. Say,
If you start paying, then you go bankrupt.
No, since I repaid my client, I said so. Otherwise,
yes.
not. Because he's to pay actually.
Yes, but because there is no affidavit, so that is how it becomes tricky. He will say that lawyer has said, I have not said. He doesn't file any affidavit, you must understand.
No,
The
he has
purpose
to
of-
file an affidavit. He has to file.
No,
Otherwise, he will file it today itself.
today.
Today he'll file the
So
affidavit.
how much?
His upper limit is 3 millions, 3 lakhs.
So you file that affidavit.
That's what I could convince him up to that only.
So
He is to
I
take
hope
loan and pay it.
obviously.
On taking loan,
Yes.
he is to pay it.
Some days after, the banks will start also lending loan on the legal necessity. Education loan, legal necessity loan, vehicle. So by what time you can furnish that affidavit?
Within a month, he'll pay it.
No, affidavit, sir.
Affidavit today.
No, time go so that I can pass order or I will, because
Maybe 3 o'clock like that.
acha, ठीक है,
2:33. 2:33.
So okay. As you would have man, I have dictated the order yesterday, but since I could not get the instruction, or maybe you could not get the instruction, the matter
Yes,
was passed over, or So if you are filing the affidavit, I will pass that order. Okay.
Okay, my lord.
So 3 lakhs is the, I mean, he has said, let him deposit that so that he can find
Yes.
a way out. You must understand that he has to find a way out.
Yes, my lord.
By simply banging his head on the wall is not possible.
Oh, no, he will be abide by that.
So it's not a question of abiding. He has lost the opportunity actually because
Correct,
of his own, yes. So if the affidavit is not filed, then again it has to come up tomorrow for to be mentioned.
No,
Okay.
no chance.
So,
Absolutely.
so what you can do, you
Has
can
to come
instruct your, I mean, learned associate that the court master will be available after court hours actually.
Yes, my lord.
So, city Kyocha, Madam Barsa would be there in the court. I think she is there. Say, so, upon tanku dei debe. So, because of this remote location VC, so there is some, these kind of issues are there because even if it is passed over, you cannot file it. You file it. ठीक है जी. The same order, Mr. Samuel Kurchand jota, se order ta achi. That order is there actually. So, la, ताणी की affidavit सही तो place करें.
Hi.
रखी दें तो अपन.
Book.
Yes.
I have taken instruction because it book.
Yes.
I have taken instruction because it was listed yesterday regarding
Yes.
that deposit.
Yes.
I have also prepared a detailed figure of the outstanding area maintenance dues. In fact,
Mhm.
the maintenance was directed to be paid from the date of the application till the judgment passed in the divorce case. Not that is
Yes.
passed subsequently. The total amount comes to around 9,62,000.
Yes.
This is for 6 years, 2 months. Then I have already paid. This petitioner has already paid 2 lakhs because the receipts are available. Receipts are available to me. Now the balance is 7,62,000. The petitioner is now prepared to pay 3 lakhs rupees for interim order to be passed.
So same thing you do, Mr. Mohanty, because again that affidavit can you file by 3?
No, today I cannot.
By tomorrow?
He's at Balasore. I am trying. By
So
tomorrow I am
you ask him to file that affidavit.
Yes.
Because you must
Yes.
understand the difficulty in passing a conditional order. Because
Yes,
if you impose a
definitely.
condition not satisfied, then there will be again it has to be listed for compliance of condition. It goes on. So
Yes,
ultimately, but like Mr. Mr. Das, he had instructions since 3 days. But
Yes, your
since,
lordship, I pass the order. By tomorrow I will filing the affidavit.
no, after you file, I'll pass the order. I'll prepare this. I'll dictate a draft order. You can say.
Yes.
Each order ହେଇଥିଲେ
ନା କିଛି
ଏ ଗୋଟେ order ଅଛି ଟିକେ ମହାନ୍ତି ଅଛି Mr. DP Mohanty for the petitioner opposite party blank. The matter was earlier heard at some length. But at counsel,
Yes,
Mr. TK Mohanty had addressed the court. It was listed yesterday on 25/2026. And the following order was passed. It is submitted by the counsel, Mr. Mohanty, for the petitioner upon instruction that the petitioner shall file affidavit stating that he will deposit 3 lakhs towards the area before the learned judge family court. How much time, Mr. Mohanty?
maybe 2 weeks time may be granted.
Within
2 weeks.
21 work, within 3 weeks.
3 weeks. Oh, much of that.
He shall file affidavit by tomorrow. The matter shall be listed tomorrow and shall retain its position in the list. जदि आपण आज आसुचंती लास्ट लाइन टा चेंज करिकी मु कर देबी
ठीक अछि
बट सेमती मैडम वर्षा वुड बी देयर इन द कोर्ट आपण जदि एफिडेविट फाइल करिवे ताको दे देबे
today it may not be possible because he's from Balasore.
No, that is how I see it.
Yes, no,
Yes.
no problem. Problem.
তাহলে tomorrow କରିଦେବି ତାହେଲେ ସେ ଅର୍ଡରଟା ଫାଇନାଲ
Again?
ଯୋଉ tomorrow ଯୋଉ ଅର୍ଡର ଡାକିଲି ସୋ ସେଇଟା ହିଁ ରହିବ ତ
हाँ,
ହଁ ଠିକ ଅଛି tomorrow ସେ ଆପଣ ଏଟା କାଲି ପୋଷ୍ଟିଂ ଅର୍ଡରଟା କରିକି କରିଦିଅନ୍ତୁ ତାହେଲେ ହେଲା yes
Item 3,
May I please, your lordships, I am on virtual, my lord. Here, my lord, this is land acquisition appeal, my lord.
Dilip Kumar Pradhan for the petitioner for the appellate yes
Yes, ma'am. Here, my lord, I have challenged the land acquisition reference which has been disallowed. My reference has been disallowed by the learned trial court against that.
so you have not made the project proponent a party
My lord.
so Supreme Court in 95 has declared the law that project proponent who pays the money has to because you have made the authority who receives the money and distributes.
Distribution. Yes, my lord.
So the other part is that did you make the project proponent party before the trial court?
No, my lord. No.
Again, that's the problem.
Yes, my lord. Yes, my lord.
So maybe it has to be remanded by making the project proponent party.
Yes, ma'am.
So
Yes.
now you have to make the project proponent party here.
Yes, my lord. Yes, my lord.
The matter is listed for fresh admission. The learned counsel for the petitioner is had. The appeal is under section 74 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013.
Yes.
Into bracket RFCT in LA, comma R&R, comma Act 2013. The appellant is a land user whose land was acquired for the Rayagada-Kereda Road, Dikhi spelling, into bracket Rayagada-Ladda,
For construction.
shifting of road for third railway line project in the district of Rayagada. The project proponent, public executing authority, public requisitioning authority is not a party before in the present appeal. Perusal of the judgment by the learned LAR&R authority in the reference on behalf of the present appellant under section 64 of the RR Act लिखिए indicates that the project proponent, public requisitioning authority, public executing authority has not been made a party. The petitioner has lived to plead the Government Union of India, Ministry of Railways, and the project and the executing agency, if any, as respondent in the present appeal. A copy of the appeal memo shall be served on the learned DSGI, on the office of the learned DSGI.
Yes.
Stop. Keep it the appropriate IA shall be filed within. IA कितने file करिवे?
My lord, within, because my lord, I have to, the client will come from Rayagada, my lord.
After vacation ताले.
Yes.
IA be filed by कितने vacation 29 रे खुलिबो.
22
The 29
रे फाइल कर देबे.
ठीक अछि ताले the application be filed by 25/6/2026. Copy be served on the learned Additional Standing Council as well as the learned as well as office of the DSGI appearing for the Union of India Ministry of Railways. Stop. Stop.
My lord, there is a noting, my lord. I have already paid the court fee, but it was earlier I paid.
Just once. Just one second. The matter shall be listed for orders in the week commencing
Complete, sir.
unfinished 6/20/26. Stop. IA 145 of 2025. The IA has been filed under section 149 of the Code of Civil Procedure, seeking extension of time to file the court fees. The office note indicates that e-court fee of rupees 3,18,585 has been paid office note देखिए office note dated 20/5/2026 has been paid. Correct. Accordingly, nothing remains for consideration in the IA. The IA starts disposed of. IA टा ऊपर नहीं जाता. IA टा ऊपर नहीं गले सुविधा हो ता तलगड़ा नहीं आसे copy serve करिबे project proposal. The Adjournment sentence in view of the judgment of the Hon'Ble Apex Court in UP Awas एवं विकास निगम versus so and so. Should I insert our seat? The petition, the appellants are include so and so, so and so. But insert करो तो कर दो. So line टा insert. Yes. Just 1 second. इतने Mr. Pradhan, Mr. Mahanti, you are there.
My lord, I am.
Mr. Respondent जो अच्छे थी, Mr. Prem Kumar Mahanti, Additional Standing Counsel for Respond. Yes.
Item 4.
May please your lord.
Mr. Asir Kumar Jena for the petitioner. Opposite party.
My lord, transfer of my lord the GR case.
Mr. Additional Standing Counsel for the Additional Standing Counsel for the opposite party. What is the ground, sir, of transfer?
My lord, the petitioner is a lady, my lord, and having my lord one my lord visually handicapped daughter.
Sir, it is not a matrimonial case. Well,
No.
Where is the cause of action?
This is
the cause of action?
This is a case of purely cheating, my lord. Lords may kindly
Pure
turn
cheating or
to
adulterated cheating? Pure cheating or adulterated cheating is not the question. So
I'm coming to that point, my lord. So far the grounds are
not that
concerned.
point, sir. So before you come to
Yes.
that point, you answer. Where
Yes,
is the
yes,
occurrence? Where is the alleged occurrence?
Occurrence, my lords, admittedly taken place at my lord the Khanpada, my lords.
Khandapada. So
My
witness and
So yes, so far the witnesses are concerned, all the witnesses are belonging to the court. Your lordship, for a moment, kindly have a glance to running page, my lord.
Now you have
1919, my lord.
So this application, this is a trial of which year?
This is a case of my lords.
In 23.
2023, my lords. Lordship.
Yes.
Then my lord.
So
Lordship,
you are referring to which provision of CRPC or Bharatiya 447?
my lord.
So
That-
you have
that-
to cite some case law where it says that wherever when a complainant or the witness resides, it has to be transferred there.
Yes, absolutely. Your lordship is correct, my lords. I'm
No,
not
I am not
disputing
correct.
that.
I don't presume to be correct. You may presume me. So I want to see that case law so that will help.
Yes, that is why I'm my lords. I am taking your
Listen,
lordship at page 19, my lords. Lordship, may kindly for a moment turn to page 19, 19, my lord.
Case law 19 रे अछि कॉपी टा ना कोन
19 charge sheet 19 page 19 को बोले आसंती.
case law Supreme Court
No.
decision. Yes, Supreme Court decision on this point that wherever the complainant resides, it has to be tried there.
Yes, my lords.
So that decision.
ନାଇଁ ମୁଁ ସେଥିରେ ଖାଲି ଗୋଟେ କଥା କାହିଁକି କହୁଛି ଯେ ସେଥିରେ କି ଯୋଉ ଚାର୍ଜସିଟ୍ ଦାଖଲ ହେଇଛି ଟୋଟାଲ ମାଇ ଲର୍ଡ 6 ଜଣ ସାକ୍ଷୀ ଅଛନ୍ତି 6 ଜଣ ସାକ୍ଷୀରୁ ଟୋଟାଲ 5 ଜଣ ସାକ୍ଷୀ ହଉଛନ୍ତି
କଟକରେ ସବୁ ସାକ୍ଷୀ କଟକରେ
Yes,
ଆପଣ
my lord.
କହିଲି ମୁଁ ଭୁଲି ଯାଉନି ମୋ ମାଇ ପ୍ରୋବ୍ଲେମ ରାଦର ଯେ ମୁଁ ଭୁଲି ପାରୁନି ସେଟା ଅଲଗା କଥା ଆପଣ ସେଇଥିପାଇଁ ଆପଣ କେସ୍ ଲଟା ପଚାରିଲେ ଆପଣ ସେଇଠି ସାକ୍ଷୀ 5 ଥର ସେଇ ପେଜ 19 ସେଇଥିରେ ଅଟକିକି ରହିଲେ ଟିକେ ଆଗକୁ ଯାଆନ୍ତୁ साक्षी जोटी केस सेठी साइटेशन टा देबे ना हां कहना टेरिटोरियल जुरिसडिक्शन सेमते डिफाइन है नहीं सीआरपीसी रे
हाँ
cause of
नहीं,
action territorial jurisdiction is defined. It is not subject to interpretation by any court, much less High Court. Even Supreme Court has not interpreted. There can be a possibility of trial being shifted by direction, of course.
ସେଇଥିପାଇଁ
So
because
this is not so this branch has not evolved. That joti sakhi joti case sethi ବୁଝିପାରୁଛନ୍ତି କି
ଆଜ୍ଞା
ଆପଣଙ୍କର bias trial, apprehension of bias ତାପରେ like the justice should not only be done but should be seen to be done. Those kind of cases have
yes
evolved.
yes
So ଆପଣ କିନ୍ତୁ ଆପଣ ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଠି ଆପଣଙ୍କର ସ୍ଲୋଗାନ
ତାପରେ ବାୟସ୍
ଛଅଟା ସାକ୍ଷୀ ପାଞ୍ଚଟା ସାକ୍ଷୀ କଟକରେ ତେଣୁ କଟକରେ ହବ ସେଟା ତ ସେଇ
ଆଜ୍ଞା।
ପ୍ରୋଭିଜନ ଟା ନାହିଁ ସିଆରପିସି ରେ
नहीं नो प्रोविजन योर लॉर्डशिप में काइंडली विजुअलाइज माय लॉर्ड्स
ନାଇଁ ଆଜ୍ଞା ମୁଁ ଆଜ୍ଞା ବହୁତ କାଇଣ୍ଡ ଯେ କିନ୍ତୁ law is unkind towards me. My problem is that I can't sit and say that since I am very kind and I am always impressed by Mr. Jena. तो ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଠି ମୁଁ ଡାଇରେକ୍ସନ ଦେବି ସେଇ ଜିନିଷଟା ଇନଭଲ୍ଭ କରିବାକୁ ପଡିବ
हाँ सेटा मु करबी जे एटा जेहेतु फ्रेश एडमिशन मैटर आसी तांक पाखु नोटिस टा जाऊ व्हाट माय आई हम्बली सबमिट
ନାଇଁ ନୋଟିସ ଦେଇ ହବ
बिना नोटिस रे कोन
ଆପଣ ଆଗ କହିବେ ନା you have to make out a case.
आज्ञा
You have to make out a case for issuance of notice.
हाँ मु बा तीनटा ग्राउंड
Parties
सेतरे
cannot be read seal Lalita. Supreme Court has
हाँ.
said. Parties cannot be ଆପଣଙ୍କର trial ରେ ଆପଣ suddenly High Court will issue notice for no reason. ଆପଣଙ୍କର ସାକ୍ଷୀ ଯୋଉଠି case ସେଇଠି I will note that proposition. You have to cite some case law on that. Then I will issue notice. I will not
ଆଉ
stop the
ସେଥିରେ କି
proceeding. ଆପଣ adjournment ନେଇ ପାରିବେ. That much I can favor you.
नोटिस टा जाऊ
ଆପଣ କହିବା କଥା
ଆଉ ସେଥିରେ କି ମୁଁ ଆଉ ଗୋଟେ
ଟିକେ ଶୁଣିଲେ ହବ ଶୁଭୁଛି ନା ଶୁଭୁନି
आज्ञा आज्ञा सुबुची
ଆପଣ ଯୋଉ କହୁଛନ୍ତି ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଠି ସେ ଯୋଉ ଅର୍ଡରଟା ମୁଁ ଆଜି କରିକି ନୋଟିସ କରିଦେବି ସେଟା ଆପଣ ପ୍ରାଇମା ଫେସି କେସ୍ କରିବେ ବିକଜ ଦେयर ଇଜ नो ସଚ୍ କେସ୍ ଲॉ or provision.
And your lordship also my lords created the law my lord
No.
yes
Adventure is
always my lord the
adventure is-
presidental law always by created by my lords and
never bereft of the statute. Never bereft of the that is not a single precedence as far as procedural law is concerned bereft of the statute.
that is why your lordship has ample power to do so my lord
ନାଇଁ ସେଟା
it can be decided my lord
ସେଟା ଆପଣଙ୍କୁ ଲାଗୁଛି ଠିକ ଅଛି but I am sure I don't have that power that I will act contrary to the statute. Which provision confers jurisdiction?
it is not contrary my lord it is not contrary my lord
So read the provision. Instead of giving a speech, read the provision. Boy ଜାଣିଛନ୍ତି ସିଆରପିସି ରେ ପଢନ୍ତୁ କୋଉଥିରେ ଅଛି ଟ୍ରାଏଲ କୋଉଠି ହବ
हम देखी my lord
ସେଠି ହଁ,
ordinary place of 177 my lord
177 ଆରମ୍ଭ କରନ୍ତୁ କୋଉଠିରେ ଅଛି
ମାନେ,
ସେ ଚାପ୍ଟରରେ ଯେ ଯୋଉଠି ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଠି
ordinary place of my lords the inquiry and trial my lords every offense shall ordinarily be inquired
ଆରେ ସେଇଟା
into
ପଚାରୁନି ସାର୍ ସେଇଥିପାଇଁ ତ ଆପଣ that is 177 is a bar 170 is against you ଆପଣଙ୍କ ଫେଭରରେ ଯୋଉ ପ୍ରୋଭିଜନ ଟା ଅଛି ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଠି କି ସେଇ ଭଳିଆ ପ୍ରୋଭିଜନ
then my lord your lords may kindly turn to
So at least at least you are fair to that extent. Chapter 13 dealing with jurisdiction of criminal courts in inquiries and trials.
my lord
So and also chapter 14 does not have any such provision.
my lord
ଆପଣ କହୁଛନ୍ତି ମୁଁ କ୍ରିଏଟ କରିବି
no create ମାନେ କି convenience so far the convenience so far the
करेक्ट कन्वीनियंस ଟା କୋଉଠି ଅଛି ସେ ପ୍ରୋଭିଜନ ଟା ଯେ ସାକ୍ଷୀର କନ୍ଭିନିयନ୍ସ ଦେଖିବେ କମ୍ପ୍ଲେନାଣ୍ଟ କନ୍ଭିନିୟନ୍ସ
section 178 my lords for a moment when it is uncertain in which of several local areas an offense was committed
ସେଇଟା ଛାଡନ୍ତୁ।
number 1 my lord
ସେଇଟା
This-
ଶୁଣନ୍ତୁ 170 is against you ଆପଣଙ୍କର ଏଠି certain it happened in ଖଣ୍ଡପଡା you have stated so also
my lord
uncertain ଥିଲେ କଣ ହବ that's not the question we are answering
yes my lord
ହଁ ଆପଣଙ୍କର ବର୍ତ୍ତମାନ ଖଣ୍ଡପଡାରୁ ଆପଣ ଟ୍ରାନ୍ସଫର ଚାହୁଁଛନ୍ତି
ଆଜ୍ଞା
Anyway, 13 ଆପଣ maybe did you read before drafting this petition 13 ମାନେ chapter 13
13 my lord
13 ତ ପଢୁଛନ୍ତି ବର୍ତ୍ତମାନ 177 198 କୌଣସି ପ୍ରୋଭିଜନ ନାହିଁ ସାକ୍ଷୀ ଯୋଉଠି କେସ୍ ସେଇଟା ତ ନାହିଁ ରାଦର ଇଟ୍ ଇଜ ଦ ଅପୋଜିଟ୍ ଯେ ଯୋଉଠି ରିପୋର୍ଟ ହବ ଏବଂ ଯୋଉଠି ଟେରିଟୋରିଆଲ ଜୁରିସଡିକ୍ସନ ଥିବ କଜ ଅଫ୍ ଆକ୍ସନ ଥିବ ନାଉ କାଇଣ୍ଡଲି ଟେକ୍ 404
404 my lord
404 ରେ ସାକ୍ଷୀ ଯୋଉଠି ସେଠି ଟ୍ରାନ୍ସଫର ହେଇଯିବ କମ୍ପ୍ଲେନେଣ୍ଟ ଯୋଉଠି
my lord section 404 my lord I'm coming
ଭୁଲ ହେଇଛି
404
407
that is BNSS my lord
ଆଜ୍ଞା 407 ପଢନ୍ତୁ ଆଉ ସେଟା ବି ଭୁଲ ହେଇ ଲେଖି ଦେଇଛନ୍ତି 407
My lord.
ପଢନ୍ତୁ
407 my lord power of the high courts to transfer the case and appeals my lord
କାଇଣ୍ଡଲି ରିଡ୍ କୋଉଠି କନଭିନିଏନ୍ସ ଅଫ ସାକ୍ଷୀ ଯୋଉଠି ସେଇଠି ହବ ବୋଲି ସେଟା ପଢନ୍ତୁ କୋଉ ପ୍ରୋଭିଜନ
number 1 my lords whenever it is made to appear to the high court
ଆରେ ସେଇଟା ତ
that a pair
ସେଇଟା ତ ଆପଣଙ୍କୁ ମୁଁ କହିଲି ସେଇଟା କହିଲି
ନାଇଁ ନା ସେଇଟା A ରେ ଆସୁଛି ଦେଖନ୍ତୁ A ରେ ଟିକେ ଦେଖି ଦିଅନ୍ତୁ
ଆଜ୍ଞା
that a fair and impartial yes inquiry or trial cannot be held in any criminal court subordinate therein my lords so here
ଆପଣଙ୍କର ପିଟିସନ ଟା ପଢନ୍ତୁ that is not your ground
no that two grounds I have taken my lords number 1
fair and impartial ହବନି ବୋଲି କୋର୍ଟ ଲେଖିଛନ୍ତି
ହଁ ମୁଁ ସେଟା ଲେଖିଛି
ଦେଖା
yes I'm coming yes my lords I'm coming there my lord
para 7 ରେ ଲେଖିଲେ frequent threat para 7 ପଢନ୍ତୁ I have come to para 7 please go to para 7
my lord kindly turn to para 6 my lords page 5 my lords
yes
my lords that it is most humbly state here that the opposite part number 2 and 3 the accused persons my lords
yes
are the local persons of Khanpada area and having influence in their locality my lords after registration of the affair against their name the 7 to 8 times given threatening to the petitioner to withdraw the case otherwise they will kill me and so and so my lord so
now you have created and so Mr. Jenna can you hear or you will continue speaking
no my lord your lordship can
so since I have read 6 and 7 I will ask you some simple thing so how can I ensure at Cuttack she will not be threatened first thing that how many times you have lost complaint or how many times you have informed the court
that I am clarifying
regarding para 6 and 7
yes,
and what is the order of the court
my lord your lordship that so far the separate incident is concerned regarding threatening about the telephone my lords
no
I am a lady
I'm not there you may be a lady or a gent that's not the point because you are talking regarding a trial the trial is proceeding so so now the problem is that without I can't ensure that it will be she will not be threatened over phone at Cuttack so you may laugh at it but it's a laughing proposition
no, that is my averment and I have filed this petition with an affidavit to that effect my lord
no affidavit you file before the trial court let the trial court respond arrest them
yes
so
they can respond my lord
the trial court at Cuttack is not more powerful than Hon'Ble
and there is no such
they cannot take cognizance of the if it is not a provision High Court cannot take cognizance
this
High Court is not a High Court if you are lodging police inaction in High Court it's a different thing but you are saying that para 6 that you have been threatened so now you have to
this is my ground this is my ground
is ground
not my ground and
so have you complained to the police regarding 6 and 7
my lord I intimated my your lordship may visualize one thing my lord I am a lady my lord for a moment my lord I am a lady
sir, you see sir Mr. Jenna for lady affair will not be lost or should be lost
no that I'm not saying that if your lordship will look at the affair itself my lords how the accused person treated
you have missed the point Mr. Jenna 6 and 7 how you have intimated the police or the court which is under trial
I have been no provision for intimation to the court where the case is my lord continuing my lord
Mr. Jenna any act by any party to interfere in the conduct of a trial has to be intimated to the court that is the provision
intimated to the court
you have to make an application that in fair and free trial the court the persons are interfering
so far the 407 is concerned my lord 407 power vested to this
Sir, not
Honorable High Court.
407. You are confused. You are reading too much of criminal law, but I am asking you something else. If you are saying that in the trial, the complainant is threatened by the accused persons, then the court has to be told. Because court will take care of that, not High Court.
My question to myself is that, my lord, to which court, my lord? That is why, my lord,
The trial court,
not,
where suppose
no such provision is there, my lord. No such provision is there to intimate the learned trial court that
You must understand what you are saying. High Court is not the trial court to ensure. I cannot direct arrest of those persons.
here, my lord,
You see,
here I am coming.
You must understand that you can lodge a complaint. If you say that there is no such provision, you can lodge a complaint before the police so that the court can take note of. I cannot direct police action against them.
No, I'm for that reason I am not before your lordship, my lord. Only because, my lord.
So basically 40 apart in 6 and 7. So you are saying that since you are threatened, so you have to substantiate that you are threatened. So you approach the court.
And additionally, my lord,
So now I will direct the court that he will take care of it. If you are saying that you have not approached the court, I will direct the court to take action.
What the learned trial court cannot, my lord, transfer the case, nor cannot, my lord, look into the matter regarding, my lord, the threatening, my lord. That is why for.
So you are thinking that I am that kind of a person who does not understand. I am not saying that. You think so, but I am not saying that learned trial court will take action against those persons regarding 6 and 7. That I will direct.
Lordship may direct.
The learned counsel for the petitioner is heard at length. Mr. Prem Kumar, Ashit Kumar Chennai. It is submitted by the petitioner before this court is the complainant and one of the witnesses. He sees the complainant.
Yes, my lord.
Complainant in Khandapada PS case number 21 of 2023, corresponding to GR case number 21 of 2023, is now pending in the court of the learned JMFC Khandapada from the learned JMFC 2 learned SDJM Cuttack. It is supporting the prayer for transfer. It is submitted by the learned counsel for the petitioner that referring to the charge sheet filed by the charge sheet annexed to the petition at page 19 regarding the witnesses 2, 3, 4, 1, 2, 3, 4,
5.
Please wait. If I require your assistance, I'll ask you. Don't worry. 1, 2 to 5. All the witnesses belong to Cuttack. Witness number 6 belongs to both. It is submitted that since all witnesses belong to Cuttack, the matter should be transferred to the Court of Learned SDJM Cuttack. In response to the said submission, the learned counsel for the petitioner was asked under which provision this court has power to transfer the case on the ground that it has to be at a place where all the witnesses reside. It is further submitted by the learned counsel for the petitioner that the cause of action is at Khandapada. The FIR was lodged at Khandapada. The petitioner being a lady, she has difficulty to appear at Hon'Ble. Therefore, it should be transferred. The learned counsel was requested to apprise any provision in the CRPC or in case law where convenience of the witness for appearance shall be the basis of transferring a pending trial from the court which has jurisdiction as defined in chapter 13 of the CRPC particularly sections 177 or comma 178. He submits that this court has power under section 407 of the CRPC into bracket since repealed and substituted by pari material provision contained in (447) of Bharatiya Nagarika Suraksha Samhita 2023. Stop. The learned counsel for the petitioner then refers to paragraph 6 and 7 of the application, which states thus. With reference to the paragraphs, the statements made by the petitioner at paragraph 6 and 7, the learned counsel is asked whether he sought for, whether she made any complaint to the law enforcement agency, and how by transfer of the matter to Cuttack, if she is threatened, as stated at paragraph 6 and 7, that can be ameliorated without the matter being informed to the law enforcement agency. It is submitted that the petitioner is a lady. She had chosen not to lodge any FIR. The learned counsel for the petitioner is also apprised of the fact that since threatening of witnesses, particularly the complainant at hearing, amounts to interference in the dispensation of justice in the pending trial before the learned JMFC Khandapada, whether any complaint or any intimation or information has been made to the learned JMFC. It is submitted that there is no such provision under law where the court under which court in which the trial is pending can be intimated if the witness is threatened or the trial is interfered with. Copy of this order shall be forwarded to the learned JMFC Khandapada to furnish a report if any if a complaint is made regarding interference with the trial, whether he can proceed in the said matter to ensure free and fair trial under the provisions of law. The reports shall be obtained by the registry by forwarding copy of this order along with the copy of the application by email to the learned court. The matter shall be listed for fresh admission in the week commencing on 30/6/2024. But add karibe, it is highlighted by the petitioner that learned counsel for the petitioner that the power conferred under 407 of the CRPC to bracket since repealed, substituted by section 447 of PNSS 2023 bracket closed, can be exercised to transfer applications, transfer trials pending, looking at convenience of witnesses and when there is threat perception to the petitioner. Yes.
Item 5.
Hello, IA is there.
I had to lie over. Unless you cite the decision today, I will pass that order. You want tomorrow? You cite the
May-
decision.
My lords, may I pray one
Tomorrow
thing,
it
my
can
lord?
come.
May I pray one thing, my lord?
What is the status of the case? Now
My lord,
now the cat is out of. What is the
my lord,
status?
cognizance has been taken, my lords.
Yes.
Yes, cognizance has been
So-
taken. Only I pray, my lords, if I will file any adjournment petition, that will be considered by you.
No.
That will be only
Because
considered by the learned
because-
trial.
With Mr. Jena, then my order will be contradicting itself. I have asked him to furnish a report because the lady is scared. Lady is scared and she is unable to appear.
Let it be liable.
Whether IA 23 of 2026, the Lorded Counsel for the petitioner insists for an interim order regarding adjournment of the proceeding. On being asked, he submits that cognizance has been taken. Stop. The matter shall lie over. Yes.
Item 5.
My lord, I've challenged the final order of the London Family Court with regard to maintenance, my lord. Whereas my source of income is the private job, and I got the
Sir, can you shift to your left, sir?
yes, lord. I'm sorry, I'm sorry. My
No difficulty.
monthly yes, my lord. My monthly salary is around 12,000.
Sir, kindly show your pleadings and evidence, sir.
Yes, my lord.
Because I have been insisting that I don't have a power to appreciate again, reappreciate, or go by the annexer or say speech of the Lorded Counsel. So, what was your evidence regarding the written statement and your evidence,
That
and
I have
how the court has appreciated?
that without any
And what is
support,
the amount? What is the amount, sir?
my lord, I am getting 12,000 per month. No, the court has granted 8,000.
Okay.
Court has granted-
So what was your evidence? Kindly go there. Go
Well,
there. First, you go to the written statement.
But that I have not filed. I am coming
So
to that.
please, whenever you are filing a revision application, make it at least legally sustainable.
Yes.
Please. So
Well, for that I pray.
no point in wasting time over your speech, sir.
Yes. For that reason, my lord, I sought for an adjournment so that I can file all these documents so that it will be appreciated by lordship.
No, I will not waste my time. I have to record the reasons of adjournment.
Yes, my
Because
lord, dear
these are
lordship.
matters where we are pressing for early disposal and completion
My lord,
of
I will not.
payment.
My lord, I will not take any time.
So
I just request-
okay.
My lord,
You-
my lord, I pray for that reason to file those documents. My lord, may I submit, my lord,
So
one chance.
whether
basis-
you pray or not, sir, I have to consider on merits today. I can't waste my time. Please appreciate. Whatever I'm
My lord.
discussing with you, I have to reflect in my order.
My lord, I sought for an adjournment only to
Yes, correct,
apprise you,
sir.
lord.
Your urgent. I'm not dismissing.
My lord,
But without giving my reasons, I will not adjourn.
my lord, unless I show, my lord, the documents which is on record, my lord, before your lordship.
Sir, you are not following,
That-
sir. You are not following. You have filed a revision. You have not examined the written statement or the evidence.
No, I'm
You
not
filed
attached to your
something
lordship.
where so please examine that. Then you make your so what is the area? What is the area here? Get the area code.
My lord, I could not follow your lordship.
এটা কোন অডিও আমার কাମ କରୁନି ଆପଣଙ୍କର କେତେ ଟଙ୍କା ଦବାକୁ ଆୱାର୍ଡ ହେଇଛି ଡାଇରେକ୍ସନ
8,000 ଟଙ୍କା per month.
କେବେଠୁ ଡ୍ୟୁ ହେଲା
21/5/2024.
21/5/24 ରୁ 21/5/26
Exactly 2 years, my lord.
ଲକ୍ଷେ 92,000 ଟଙ୍କା
ଆଜ୍ଞା।
କେତେ ଦେଇଛନ୍ତି
ଦେଇନି because she has voluntarily
ଆପଣ
left. That is
ଆଜ୍ଞା?
she has voluntarily left. That is my evidence.
ହଁ
In
ସେଇ ଯୋଉ
spite of that, my lord, I am willing to pay.
ସେଟା ଟ୍ରାଏଲ କୋର୍ଟ ତ ଡିଲ୍ କରିଥିବେ ନା କୋଉଠି ଡିଲ୍ କଲେ ଭଲଣ୍ଟାରୀ ଆପଣ ତ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଜାଣିନାହାନ୍ତି ଆଉ କଣ କହିବେ ବର୍ତ୍ତମାନ
Sir, that is why, my lord, to apprise, my lord,
ହଁ ଠିକ ଅଛି
my lord, I am willing to deposit as per your lordship.
You are Mr.
NK Sahoo, my lord.
Mr. NK Sahoo for the petitioner. Mr. Opposite party blank. The petitioner before this court is the husband in the marriage. He challenges the judgment dated
26th January.
24/1/2026 26 January down, Republic Day.
24th
26 passed by the Learned Judge Family Court Jajpur. In criminal proceeding number 120/2024. The said application was initiated under section 125 of the CRPC into bracket since repealed and substituted by section 144 of Bharatiya Nagarika Suraksha Samhita 2023 bracket closed, seeking monthly maintenance for the wife in the marriage. At the rate of 15,000 per month. Seeking revision of the application, seeking revision of the judgment, it is submitted by the learned counsel for the petitioner that the petitioner earns rupees 12,000 per month as his salary. For which he has annexed a salary slip of January 2026. Gross salary 18,258. Net salary 11,801. The second ground of challenge seeking revision is that the petitioner voluntarily has left the company of the opposite party. The reliance of the salary slip for the month of January 2026 is thoroughly misconceived as the hearing was concluded on 21/2026. The petitioner hearing did not adduce any document before the learned trial court, which he is trying to do at the stage of revision, which is not permissible in view of the law laid down by the Honorable Supreme Court in Samima Faruqi versus Sahib Khan. Paragraph 19 and 20 quote कर दें. Regarding voluntary desertion, regarding the allegation that the opposite party has left the company of the petitioner voluntarily, the learned counsel for the petitioner is also apprised of the law laid down by the Honorable Apex Court that in Samima Faruqi Supra, that would be a matter of pleading and evidence. Now the petitioner, learned counsel submits that she has not filed the pleadings of the petitioner herein as opposite party before this court, and the matter may be adjourned. Stop. The learned counsel is also apprised of the decision of the Honorable Apex Court in Rajneesh versus Neha, citation Debe, wherein it has been held that the maintenance directed to be paid under an application filed under section 125 of CRPC amount is akin to a money decree, to challenge the same, the petitioner has to secure the amount. Stop. Upon instruction, it is submitted by the learned counsel for the petitioner that, as per his instruction, the petitioner has not paid any amount pursuant to the direction of the learned judge family court under the application. In the by judgment dated 24/1/26 pursuant to the application of the wife. Stop. The petitioner shall file affidavit indicating how he will secure the amount of arrears that comes to 24 गुणन 8,000, 1,92,000. Stop. The as prayed for, to grant further opportunity to the petitioner, the matter shall be listed for fresh admission. In the week, you want by tomorrow, can you file affidavit? Deposit the money.
No, my lord, it will be difficult.
So when your client told you that he earns 18,000, you should have asked how much he will pay.
Yes, he's willing to pay. It's not that he's not willing to pay.
So his willingness will not help him. His payment will help him.
My lord,
The matter shall be listed for fresh admission in the week commencing. When do you want, sir?
just after vacation, my lord.
29. The week commencing on 30/4/24. Yes.
Yes, ma'am.
Item 6.
May I please, Your Lordship?
Yes, please. Mr. Kabir Kumar Jena for the petitioner,
Ma'am,
opposite party, land.
here the annexer 5 is the impugned, my lords. The
Yes.
Learned family judge Jajpur, my lords, the past order and the final judgment, my lords, on 9/4/2026, that is impugned, my lordship, that
Yeah.
without considering the pleadings of the present petitioner and
Kindly show that. Kindly show your pleadings, sir.
the annexer 2
Yes.
is my purpose reply, my lords.
No. Annexer 2.
Annexer 2, my lords, at page 16.
You may not be prepared, but don't display it in public that I am more prepared.
My lord,
Annexer 2.
Annexer 2 is the so-called reply filed by the present petitioner before the family court Jajpur, my lord.
So where you have stated regarding your grounds?
I'm
Who
stated, my lords, that is paragraph 5, my lords. And paragraph 5, I have stated that the wife opposite party is earning more than 10 to 15,000 rupees per month as tailoring, putting in a tailoring shop, my lords. And
Okay, so kindly show your when you cross-examine the wife, show that tailoring shop.
You not can see the judgment in the
cross-examination kale judgment କହୁଛନ୍ତି.
No minutes, I am not
So
cross-examining.
ଛାଡି ଦିଅନ୍ତୁ ତାହେଲେ ଯୋଉଟା ଆପଣଙ୍କର, you see, you are the defendant. When you are attributing the wife earns 51,000 or 15,000 from tailoring, that you have to put to your wife. And she has to say that yes, I am obtaining, or whatever she says, let us see. So you have to show that. By stating before a court in the written statement will not help you, because you are not the plaintiff, you are the defendant.
I am the defendant. Yeah.
Whenever you are making a counter case, you have to put that.
But so far as my income is concerned, my lords, the Annexer 3 series I am saying that
first again pleading. ଆପଣଙ୍କର ପ୍ରଥମେ pleading କୁ ଗଲେ ସିଆଡେ cross examination ଦେଖି ନାହାନ୍ତି. ବର୍ତ୍ତମାନ ଆପଣ pleading ଦେଖାନ୍ତୁ, ଆପଣ କଣ କହିଛନ୍ତି?
though Learned family judge stated in paragraph 4 that I am participated in the proceeding, but actually it's a ex parte order. Actually it's a ex parte order, my lords. I am not participated.
Actually ex parte ହୁଏନି. ଆପଣ ଯୋଉ ଦିନ order ହେଲା ଆପଣ ଗଲେନି ସେଦିନ ex parte ହବ. ସେମିତି ଆପଣ appear କଲେ, written statement ଦେଲେ, ତାପରେ ଆଉ ex parte କେମିତି ହବ?
written statement
ଆପଣ
I have
ଯୋଉଦିନ ଆପଣ ଯୋଉଦିନଠୁ କୋର୍ଟ ରେ ପାର୍ଟିସିପେଟ କଲେନି ସେଦିନ ଏକ୍ସପର୍ଟି ହେଲା ଆପଣ ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲେ ହେଇଥାନ୍ତା ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି ବୋଧେ
there is no order of expert, my lord. The annex,
ସେଇଟା ଏଣ୍ଟାୟାର ଅର୍ଡର ସିଟ୍ ନ ଦେଖିଲେ ହବନି
your lordship kindly, my lord, I am applied for the entire order sheet for the
ଏନିୱେ ଆପଣ ଆପଣ ଠିକ ଅଛି ଆପଣ ଦେଖାନ୍ତୁ କୋଉଠି ଷ୍ଟେଟମେଣ୍ଟ ଆପଣଙ୍କର ଅର୍ନିଂ ବାବଦରେ because I can't have a different view in different cases. I just had one matter of Mr. Sahoo. I'll take a different view here.
obtain it. May I audible, my lord?
ଆପଣ ଟିକେ ପଢନ୍ତୁ ଟିକେ ଜଜମେଣ୍ଟ ଟା ପଢନ୍ତୁ ପାରା 5
My lords, the petitioner only examining herself as PW1, my lords. But she does not rely upon any document from her side, my lords.
Yes.
The wife does not rely on any documents.
Sir, I don't need explanation. ମୁଁ ବୁଝି ନ ପାରିଲେ ପଚାରିବିନି କହିବିନି ଆପଣ ପଢନ୍ତୁ. On the other hand, UP neither examined any witness nor exhibited any documentary evidence.
Evidence.
High Court ରେ କଣ ହବ କିଛି ହେଇପାରିବନି.
Lordship kindly just paragraph 4, my lords.
Lordship just ଜଣେ କହୁଛନ୍ତି ଯେ ମୋର enormous power ଅଛି ମୁଁ ସବୁ କରିପାରିବି. But ଆପଣ ତ ଫେରେ revision ର scope ଦେଖିବେ.
My lords, he
cannot entertain evidence now.
I have failed to file a written statement, my lords. The judge family court stated, paragraph 4. But I filed it. They have not considered the written statement filed by
ସେଇଟା ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ହେଲା ଆପଣ ଯେତେବେଳେ ଡ୍ରାଫ୍ଟ କଲେ ଦେଖିଲେନି ଆପଣ କୋଉଠି ସେ ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି ଆପଣଙ୍କର ରିଭିଜନ ରେ ବର୍ତ୍ତମାନ ମୁଁ ପଚାରିଲାରୁ ଆପଣ ଏଟା ଦେଖୁଛନ୍ତି because I have to read the way it should be read ଆପଣ କୋଉଠି ସେ ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି ରିଭିଜନ ରେ
my lords,
ଆପଣ ଯେତେବେଳେ sir you are a seasoned counsel when in fact all of you are seasoned whenever you are presented with this situation you should have checked it ବର୍ତ୍ତମାନ ଆପଣ ସିଓର ନୁହନ୍ତି କି ମୁଁ ବି ସିଓର ନୁହଁ obviously I can't be sure ଆପଣ ତ ଅଧିକା କଣ ଜାଣିବି ଯାହା ପଢିକି ତ ଜାଣିବି if you want issuance of notice arrear କେତେ ଟଙ୍କା ଦେବେ ସେତିକି କୁହନ୍ତୁ I will consider that.
The petitioner is a reporter, but now because of the putting in a
sir reporter ମାନେ exempted ତ ନୁହନ୍ତି ନା ଆପଣ ଯଦି reporter exempted ସେ plea ନେଲେ ତାହେଲେ adjudication ହବ.
What is my problem, my lords? When when the requirement of love and affection of wife, when he is made a road accident and severely suffer, my lords, the annex 3 is the entire medical papers I annexed.
Yes, ସେଇଟା ଆପଣ again Mr. Jena you have missed the point. ठीक है judgment ଟା ଦେଖିବେ ଆଗ judgment ରେ କଣ evidence ଅଛି କିଛି ନାହିଁ ଆପଣ ତାପରେ ଆପଣ ଅନ୍ୟ ଜିନିଷ ପଢୁଛନ୍ତି which is a recipe for disaster. Neither you can rely nor I can entertain.
ମୁଁ ଯେତେବେଳେ ମେଡିକାଲ ରେ ପଢିଛି ସେତିବେଳେ ଫଲ୍ସ ଆଲିଗେସନ କରିକି ସେ
ଆପଣ ସେଟା କାହିଁକି କୋର୍ଟ ରେ ସେ ଯୋଉ ସେଟା କାହିଁକି କୋର୍ଟ ରେ ଦେଲେନି ଆପଣ ପାରା 5 ପଢିଲେ ନା ଏବେ ପାରା ପଢିଲେ ଆପଣ କିଛି ଦେଇନାହାନ୍ତି ତାପରେ ବର୍ତ୍ତମାନ ଲୟର କୁ ବ୍ଲେମ କରିବେ ଲୟର କଣ ମେଣ୍ଟେନାନ୍ସ ଫାଇଲ କରିବେ I don't understand this.
No, my lord, I am not.
So you have to inform the court.
Well, the income of the present petitioner was 13,000 per month.
Sir, 13,000 or 3,000, sir. You have to present to the court, or you will. So the only way you deposit amount, I will issue notice. Maybe after that, 127 ଆପଣ ଫାଇଲ ଆପଣ କେତେ ଟଙ୍କା ଦେବେ ପଚାରିଲେନି?
My lords, I will take instruction, my lords, in this regard. How much amount he will deposit?
Same order କରିଦିଅନ୍ତୁ. Same order like the last matter.
My lords,
item 5 ରେ ଯାହା order 6 ରେ ସେ order କେସ୍ ନମ୍ବର ଚେଞ୍ଜ କରିଦେବେ.
Oblige.
This cannot be reopened here in revision. If you read that judgment of Honorable Chief Justice Deepak Mishra, he says that this is, in fact, that is the law, of course.
But the appeals court judgment matters in Neha versus Rajinish, that has not been complied by the non-judge family court matters. No, neither of the parties had filed their.
So say आपण Rajnish versus Neha पढ़िबे सेटा फाइल न हेले देई हबनी बोली कोठी नाही.
Yes, sir.
आपण सेथिरे 20 लाख 50 लाख जो दउचंदी सिए 5000 2000 5 एठी आपण 8000 ଆପଣଙ୍କର daily wage calculation कले daily wage cancellation कले it comes to around 8000 actually. सेही Rajnish versus Neha रे जो अछि आपण जे daily wage calculate करिवे ताले हबो.
Here 12,000.
In many cases, I find somehow nothing is presented to the trial court.
Minors. That is the whole difficulty. Minors.
In some cases, even it is rejected by what trial court. 125 is rejected, 24 is rejected also.
Minors.
But it has to be placed.
Yes, minors. That is the whole difficulty. Minors presenting different errors.
Yes, system. Next.
Oblige.
Item 7.
Item 7, my lord.
Same order as in 5. You 5 रे जहाँ order करछि 6 रे से है.
So we commencing on 3.
We commencing on 36. Kindly unmute, Mr. General. Kindly unmute.
Yes. Item 7, my lord.
Antarish Cha. Yes. 7.
7, my lord, petition the husband, my lord, challenge the order of the maintenance passed by Noyagad Family Court, Noyagad, my lord. Wherein the family court directed the petitioner, the opposite party, husband, to pay 3,000 rupees to the wife and 3,000 rupees to the son, my lord. That is total 8,000 rupees. My humble submission, my lord, the family court had disposed of 3 cases. One is section 9 filed by the wife and section 125 filed by the wife, my lord. Once section 9 allowed the petition and directed the opposite party husband to facilitate the petitioner 1 along with the minor son to resume cohabitation within 3 months of this order. That means directed to stay under one roof, and another file directed to pay maintenance, my lord. That is, I'm ready to, my lord, to comply the order.
Mr. Nayak, apart from getting impressed by this logic told by your client, your duty is to read case law. This question has been answered by the Supreme Court.
Well,
when we are talking, we cannot talk like your client and you are the now client, I am the lawyer, or I am the client, you are the lawyer. This question has been answered by Supreme Court in a decision.
The fact is, my lord, and the amount I have
problem है जे आपण गोटे fast point टा कले fast completely against you.
I am ready, my lord, to constitute conjugal life.
सेटा हेई परिबनी 125 रे से प्ली अवेलेबल नाही. आपण को readiness for conjugal life will not be a ground to refuse maintenance. को case
on to the order, my lord.
That is the problem. When you do not prepare and read and so where you have taken stand that conjugation, have you stated that?
Ground I have taken, my lord.
अरे ground नो written statement कौन फाइल कले ground हैं
my lord
written statement रे एटा कहितले
ना एटा my lord I have not mentioned, my lord.
ताले काई सिथरे पछन दिया गया किछि तो पढिबेनी किछि देखिबेनी. Again, this is not common logic or common sense. We are not discussing in a court common sense or common logic. आपण जोटा कहउछथि मते भी भल लागुछ सेटा. Perhaps that could be my view also. But that is not a legal view. That's illegal.
Apart from that, my lord,
ଆରେ ଆପଣ ଗୋଟେ ଜିନିଷ ଆଗ ଛାଡ଼ନ୍ତୁ, ଗୋଟେ ଜିନିଷ ଯୋଉଟା କହୁଛନ୍ତି ବହୁତ ଜୋରରେ କହିଲେ ସେକ୍ସନ 9 ଅର୍ଡର ହେଲା, ସେ ପ୍ଲି ନେଇନାହାନ୍ତି। ଆପଣ କଞ୍ଜୁଗାଲ ରାଇଟ୍ ଲିଡ୍ କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି, ସେ ଆସୁନାହାନ୍ତି, ସେ ପ୍ଲି ବି ନେଇନାହାନ୍ତି।
No, what happened? Why cannot plead?
ଆପଣ ଫାଷ୍ଟ ଦ ପ୍ରୋବ୍ଲେମ ଇଜ ଦ୍ୟାଟ୍ ନାଉ yes come to the second point.
Well, since you order diagram pass kale section 9 and section 25 रे one day order pass my lord. One day say same day order
ଆରେ
pass.
ସେ ବାଧ୍ୟ କରିବା ପାଇଁ ସେକ୍ସନ 9 ଆଉ ସେକ୍ସନ 125 ବିକଜ ଆପଣ ତ ନିଜେ ଆର୍ଗ୍ୟୁ କରିନଥିଲେ ମ୍ୟାଟରଟା,
ନା ମିଳିବ।
ଆପଣଙ୍କୁ ଏଟା କାହିଁ ଲାଗୁଛି ଏଟା ହେଇପାରିବନି ବୋଲି? ହ୍ୱାଟ ପ୍ରୋହିବିଟ୍ସ ସେକ୍ସନ 9 ଆଉ ସେକ୍ସନ 125 ହେଇପାରିବନି ବୋଲି? କୋଉଠି ସେଟା ପାଇଲେ?
And I will
ସେ ଯେ ଆପଣଙ୍କୁ ବ୍ରିଫ କରୁଛନ୍ତି ସେ ବି କିଛି ପଢିନାହାନ୍ତି।
my income
ପଢିଛନ୍ତି କି? ଫାର୍ଷ୍ଟ ଅଫ ଅଲ୍ ହାଭ୍ ୟୁ ରେଡ୍ ଏକ୍ସାମିନ୍ ଦିସ୍ ପଏଣ୍ଟ? ମାଇ ଇନକମ୍ କଣ କହୁଛନ୍ତି? ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଯେ ସେକ୍ସନ 9 ରେ ହେଲା ରେଷ୍ଟିଟ୍ୟୁସନ, ସେକ୍ସନ 125 ରେ ହେଲା ଗ୍ରାଣ୍ଟ ଅଫ ମନ୍ଥଲି ମେଣ୍ଟେନାନ୍ସ। ହେଇପାରିବନି ସେଟା କହୁଛନ୍ତି।
That is very common. My lord. If wife is stay with me.
When Mr. Das Naik, we should not laugh at legal propositions. You are laughing at Supreme Court.
No, my lord, certainly not. The Hon'Ble court.
Puja Kumari, Dinesh Mahato. Rina Kumari versus Dinesh Mahato.
My lord.
AIA. गला फास्ट प्रपोजिशन बहुत भाभी चिंती कहले गला सेटा। You are laughing at Supreme Court and you will say that you are laughing at Rina Kumari versus Dinesh Mahato.
This one, my lord, did.
कौन करा जिवो गला तो कौन तापर नेक्स्ट पॉइंट बाकी
Next point, my lord.
I would Mr. Naik, you must look at the pleadings before you start applying your common sense and read by the lawyer who doesn't read anything. This should have been argued there also, I think. ଆପଣ କୋର୍ଟରେ ପ୍ଲିଡିଂ ନେଇଛନ୍ତି ଯେ ସେ କଣ ପ୍ଲିଡିଂ କିଛି ଦେଖିଛନ୍ତି?
My lord.
ରିଭିଜନରେ ଆପଣଙ୍କ ଟ୍ରାଏଲ କୋର୍ଟ ପ୍ଲିଡିଂ ଯଦି ନଥିବ ବର୍ତ୍ତମାନ ରିଭିଜନରେ କରିହବ
ସେଟା କରି ହବନି କିନ୍ତୁ
ସେଟା କାହିଁ ଆପଣ 127 ରେ କଣ କରିବେ ସେଟା ଅଲଗା କଥା, but this you cannot argue before this High Court because the problem would be it is not only revision in any matter. Why the appellate court or the revisional court cannot look into other matter? The reason being that then it becomes endless.
Second point,
ସବୁ କୋର୍ଟରେ ଯଦି ଗୋଟେ କଥା ନୂଆ ପ୍ଲି ନେବେ। ସେକେଣ୍ଡ ପଏଣ୍ଟ କଣ କୁହନ୍ତୁ? ଫାଷ୍ଟ ତ ଆପଣ ଲାଫିଂ ଆଟ୍ ସୁପ୍ରିମ କୋର୍ଟ ଗଲା ରୀନା କୁମାରୀ versus
second point, my lord, the page 70 of the order, my lord, page 70, my lord. It is the convincing them. I am leading the relevant person. It is also convincing that during her interim stay from 8/9/23, the opposite party served her divorce notice. As such, the allegation that the petitioner had deserted the opposite party since 2018 without any reason cannot be accepted by any state of imagination, my lord. Another point is sorry, my lord. Madam.
अरे ଆପଣଙ୍କ ପ୍ଲିଡିଂଟା ଦେଖିଲା ପରେ ତାପରେ ଜଜମେଣ୍ଟ କୁ ଯାଆନ୍ତୁ। ଆପଣ କଣ ପ୍ଲିଡ କଲେ, କଣ ଏଭିଡେନ୍ସ ଦେଲେ?
I have given my income certificate that you have exhibited at exhibit H, my lord.
हां कौन केते एग्जिबिट एज केते सर कोंतो
12,000, my lord.
12,000 टू से केते देले?
See, my lord, the opposite party failed to establish, my lord.
अरे फेल टू एस्टैब्लिश कोन हो? आपण कोन कहउचंदी कोन? आपन इनकम सर्टिफिकेट रे सी कोन फेल टू एस्टैब्लिश? 12,000 आपणकर 12,000
my lord.
अवार्ड केते हैला मेंटेनेंस?
3,000, my lord, to wife and 2,000 to the wife, my lord. That is total 5,000 to the
माने आपण छुआ को को ग्राउंड रे देबेनी?
छुआ के 3,000
टंका सुनंतु हाई कोर्ट और सुप्रीम कोर्ट कहले ओडिसा कोर्ट कहले अबाउट 40%,
my lord.
सो आपण को 12,000 40% रे 48,000 4,800 सॉरी आपण तो 3,000 ହେଇची कम ହେଇची। आपण कोन एनहांसमेंट चाहउछन ना कोन?
ना 5,000 ହେଇची माने wife को
this kind of things
माने total
but are you saying that you will not maintain your child na कोन?
No, I am ready, my lord. I am duty, my
So
lord.
you keep on, so don't bring the child into this fold.
No, total one 8,000.
total even the wife is entitled for 5,000 4,800. So the court thought that आपन 12,000 तेणु कमेगी कले 4,800 तो टोटल 3,000 कले असुविधा कोन है
No, wife कले 5,000 rupees, with child को 3,000 मिला, total 8,000 मिला, total 8,000 rupees.
प्रॉब्लम इज दैट आपनकर चाइल्ड को आपन डिनाय कर परिबेनी ए जो ग्राउंड रे वॉलंटरी डिजर्शन आ गोटे कोन कहले सेक्शन 9 चाइल्ड मैरिज सेक्शन 9 फाइल हेतले
माइलर
हिंदू मैरिज एक्ट रे कोन चाइल्ड नारे सेक्शन 9 फाइल हेतले ना कोन
माइलर
चाइल्ड कोन सेक्शन 9 फाइल हुए चाइल्ड नारे माइलर
सेक्शन 9 फाइल कर दिले मदर एंड सन
कोन मदर एंड सन को प्रोविजन रे अछि चाइल्ड माइनर चाइल्ड पे सेक्शन 9 फाइल हो
वो जहां फाइल दी केस माइलर
अरे सेक्शन 9 आपण कंफ्यूज है 125 को 9 बदे कहउछन आपण तीन चार थर 999 चलै छथि 125 फाइल कले मदर एंड सन
माइलर
आपण सेक्शन 9 जो फाइल कले कोन वाइफ को छुआ को भी पार्टी कर ना कोन
आई एम नॉट पार्ट
ताले काई सेटा काई आधे भर्ती करू
सेक्शन 9 फाइल बाय द वाइफ माइलर
आपण छुआर मेंटेनेंस कथा कोंतुनी आपण 3000 देबे कोन करिवे सेटा आपनकर कर्तव्य आपण करिवे कि न करिवे सेटा बुझिवे वी आर नॉट डिस्कसिंग दैट नथिंग यस एनी अदर पॉइंट
the amount is very high, that is my problem mailor the 5,000
in today's cost 5,000 for a person आपण 5,000 नहीं चलिबे
मतलब आई एम इन माय इनकम इज
12,000 रे चलिबे चलिबे बाकी हां आपनकर 5,000 आपनको वाइफ कर आपण केते दउ चाहउछन
माइलर माय कैपेसिटी माइलर 4,000 माइलर मैक्सिमम
4,000 डिपॉजिट करंतु
इन मीन टाइम माइलर एग्जीक्यूशन के फाइल माइलर
आपण एग्जीक्यूशन ने 4,000 डिपॉजिट कर दियौ तो 4,000 के
एनबीडब्ल्यू आर इशू माइलर दैट इज आई फाइल आईएमएल फॉर स्टे माइलर
हबनी पैसा न देले एनबीडब्ल्यू स्टे हबनी से आपन को पचरिबेनी आज्ञा जे ताको छुआ को छोटो छुआ को पचार ना से वकील को पचरिबे ए आपण वकील मेंटेनेंस फाइल करिवे ना कोन
ना दैट इज डिफिकल्ट इज माइलर एनबीडब्ल्यू इशू माइलर
हां आपण 4,000 लेखा केते टका एरिया दियंतु काली के आसीओ
what's the matter
आपण एडमिट काई कले सेटे आपण होमियोपैथी डॉक्टर बोली आपण जे होमियोपैथी डॉक्टर क्लिनिक जानते एबे जाउछन्ते आपण जो भिड़ होउची पैसा नउछ
माइलर आई एम वर्किंग ऑन द डॉक्टर माइलर आई एम नॉट एक्सपीरियंस डॉक्टर माइलर आई एम वर्किंग ऑन द सीनियर डॉक्टर माइलर एज असिस्टेंट्स
आपण सीनियर जूनियर कोन माने वकील क्लाइंट आसुना देने कोन
नहीं से आगे होमियोपैथी एक्सपीरियंस पे निर्भर करे माइलर डिफिकल्ट टू डायग्नोसिस
आपनकर एडमिशन ला एग्जामिनेशन चीफ की क्रॉस रे जे आपण होमियोपैथी डॉक्टर तापरे कहबे जे मु जूनियर डॉक्टर तेनो आपण गले जो भिड़ होची से छकरे होमियोपैथी क्लिनिक रे केटा नोचंती पर डे इनकम आपनकर ताट अधिका जा दिया आइची पर मंथ अब पर डे अधिका ताट इनकम Sir, we are not living in a isolated world. You must understand.
I understand, that is not difficult.
Mr. Nayak, you should have asked this question to your client when he is making your absolute bluff before the lawyer. You're taking the lawyer for a ride. You should ask these questions.
My humble submission, my lord.
Then you will respect him.
I am humble submission, my lord. As the NBW issue, my lord.
Deposit करिवे NBW किछि step हबो. Deposit काली करंतु. टोटल अमाउंट ड्यू केबे टू रहला
एक तो भी रहला जे कि 30 से 23 माइलर इट इज प्रोबब्ली टू मोर देन 2 लाख
इठी आगा होमियोपैथी काम करिवोनी एटा इंटेंसिव केयर दरकार नॉलेज हबनी इंटेंसिव केयर रे खर्च हुए खर्च भी किछि नहीं पर्सनल खर्च से दे देबे हस्बैंड एंड वाइफ को सॉरी वाइफ और चाइल्ड ठीक आईसीयू रे पड़िबे तापर हबो एतरे स्टे हबनी नले गले आपण
I am ready to pay, my lord.
सबुठी होमियोपैथी लगेबे आपण को रेडीनेस टा को कन्वर्ट करंतु
my lord
होमियोपैथी रे प्रिंसिपल है डाइल्यूशन बुझले कि एटी डाइल्यूट हला हबनी डिपॉजिट करंतु टका
मैं डायरेक्ट my lord I will pay deposit my money my lord before the court.
अरे मु कहीं डायरेक्ट करिवि आपण केते एफिडेविट से थरे डायरेक्शन देला पर से चलिबो कंडीशनल ऑर्डर हेले से सरीबोनी से डेफर आपण डिपोजिट करी आसु कोन काली आज नै कि ड्राफ्ट दे देबे फोन रे कोन
Difficult माइलर होने एनबीडब्ल्यू इश्यू माइलर आई मे बी अरेस्टेड बाय
सुनन तागे एनबीडब्ल्यू इश्यू नतले से आपण को भी पचारंतनी जे ता छुआ को पचारोनी से कोन पचारिबो कहली पर आपण तोरा हाउ आई विल एक्सप्लेन यू इटी होमियोपैथी काम करिवनी इटी सुप्रीम कोर्ट का डायरेक्शन अछि अबकर 5000 8000 8000 को हे गेलानी 36
मोर दैट
36 3 प्लस 5
more than 2 lakhs मतलब से केबे सिला 23
3 लाख 52,000
ये 2 लाख ऊपर हो जाएगा
नहीं सॉरी
2 लाख 32,000
मैथमेटिक्स आपण होमियोपैथिक रे मैथमेटिक्स भी गला पर आपनकर 23 रु 26 हला 25 सॉरी मोर गला होमियोपैथिक खाई 24 24 3 27
24 29 मास 29 मास
29 हो
29 2 लाख 25,000
32 मास हो में जाए 32 मास हो
में जाले 32 मास 5
डिपॉजिट कर दियंतु आज 2,56,000 डिपॉजिट कर दियंतु
हां एते को दे परियो आज्ञा
हां ना होमियोपैथी खाई रहइबो
ना पॉसिबल तो टंका दे परियो कि अल्प अमाउंट कले डिपॉजिट
दिस इज रिडिकुलस जे आपण होमियोपैथिक डॉक्टर एठी आसी कि 5,000 टंका को कहिले आपण कम कहिले बोल से कम करछंती
मते लागे विडो मदर इज आल्सो विथ मी माय लॉर्ड
आज्ञा मदर विडो हे गेले 125 इज नॉट ए बार कोन ता पले ये विडो हे जेबे ना कोन आपण जेमिति से वर्तमान जेमिति विडो मदर मने पड़छन सेमिति स्त्री और छुआ को मने पकांती
माय लॉर्ड फैमिली कोर्स डायरेक्टेड माय लॉर्ड टू मेंटेनेंस इज पेबल टू द
आपण ताको 2,56,000 कहंतु यू सीक इज रेस्पॉन्स जदी
आल्सो डायरेक्ट इंस्टॉलमेंट करिसन से दवा पे नोटे इंस्टॉलमेंट कले म टंका दे दियंतु
आज्ञा आपण से निजे ताके सारे कथा होंतु निजे आपण केते टंका देबे काली सुधा कहंतु काली मैटर आसियो आज डिपॉजिट करंतु
40,000 माय लॉर्ड
ना बार्गेन करंतु नी ये कोन होमियोपैथिक मेडिसिन सस्ता बोली
से 10टा इंस्टॉलमेंट ऑर्डर आके हिची 10टा इंस्टॉलमेंट दबी ऑर्डर करिसंती ऑर्डर
10टा इंस्टॉलमेंट एरियर देबे बोली करछन
हां which is payable the petition of the party in 10 equal installment on or before 10th of the each succeeding month that is the time has passed no 10टा installment
ताले आपण ड्यू इंस्टॉलमेंट देखु नांती ता भी करंतु 16 2 26 हेले आपनकर इंस्टॉलमेंट आपनकर पूराटा ऑलमोस्ट एरियर अछि आपनकर हेलानी 17 2 26
17 26 माइल 29 मास हिसाब
ताले 29 मास होची
आज्ञा 29 मास
29 को
2,32,000
एते हबो 1,97,000 हो
आज्ञा
एरियर आपनकर 29 गुणन 8,000 ना
आज्ञा
ताकू 10 रे डिवाइड करले 2 लाख धरंतु
आज्ञा 2 लाख
20 प्लस मार्च अप्रैल मई जून 36 ठीक अछि 50,000 काली डिपॉजिट करंतु हला काजी डिपॉजिट करी काली आसंतु
आज डिपॉजिट नयगढ़ टिके टाइम देले
नयगढ़ आगे हमर इंडियन स्टैंडर्ड टाइम अच्छी सेटा नयगढ़ टाइम और कटक टाइम अलगा ना कोन से आपण को नले होमियोपैथी प्रेस्क्रिप्शन धरे पळेबे जे छोटो छुआ को कहउछथि 2,000 टका बेसी हे गला 3,000 टका बेसी हे गला से ताकर से किछि वीडियो मजर को बिल्कुल पचारंतिनी गोटे मनुष्यर इतिकी मानविकता नाही
प्रैक्टिस भलो चालु न सेटा प्रॉब्लम है
सितरे आपण कोन जाइतिले प्रैक्टिस से आपण सेटा कहिबे से एनबीडब्ल्यू पे आपण पचारछन स्टे हेले भी से आसीबे
नहीं तार वीकनेस पिला को तार वीकनेस अछि
आपण भी सुनंतु आपण 60,000 कहंतु मटेरियल इंस्ट्रक्शन भी आपण नले आ मिलिबन प्रिस्क्रिप्शन धरे देबे आपण धळा गुली खाइबे ता
ତ ଗୁଲି ଚାଲ ତାର ଡିକୋଡ୍ ଦଉଛନ୍ତି ଆଜି।
ତେଣୁ ଆପଣଙ୍କର ବି ନାହିଁ, ତେଣୁ ଆପଣ କୁହନ୍ତୁ ତାଙ୍କୁ ଆଜି ଡିପୋଜିଟ୍ କରିବେ, କାଲି ଆସିବ ସକାଳେ।
ମ୍ୟାଡ଼ାମ ଟେକ୍ ଇନଷ୍ଟ୍ରକ୍ସନ ମାଇ ଲର୍ଡ।
ଆରେ ଇନଷ୍ଟ୍ରକ୍ସନ କଣ, 40,000 ବି ଦିଅନ୍ତୁ, ଡିପୋଜିଟ୍ କରନ୍ତୁ।
ଆଜ୍ଞା ଆଜ୍ଞା ସାର୍।
ଆପଣ ତ 40 ମୁଁ 50 କହିଲି। Even I have gone by your words. Today is the last day. I am not I mean ଏ ଯୋଉ ଫିସିଂ ଏକ୍ସପେଡିସନ ନୁହଁ କି, ମୁଁ ଏଥିରେ ଜମା ପଶୁନି।
ଅର୍ଡର ପାସ୍ କରେଇଲେ
କଣ୍ଡିସନାଲ ଅର୍ଡର ହେଲେ ତାପରେ ସେ ନା କମ୍ପ୍ଲାଏ କରିବେ ନା ବାରମ୍ବାର ମ୍ୟାଟର ଲିଷ୍ଟ ହବ, ୱେଷ୍ଟେଜ ଅଫ ଟାଇମ। ତାଙ୍କୁ କୁହନ୍ତୁ ଷ୍ଟ୍ରେଟ୍ ଆପଣଙ୍କର 10 ତାରିଖ ଭିତରେ ତାଙ୍କର ହଉଛି 8,000 ହିସାବରେ 8,324 ଏରିୟର ହେଲା, ଠିକ ଅଛି। 45,000 ହଉଛି, ଠିକ ଅଛି, 40,000 ଦିଅନ୍ତୁ।
ଆଜ୍ଞା ମାଇ ଲର୍ଡ। ମାଇ ଲର୍ଡ।
Now kindly listen to the order. Mr.
Lord.
Radharaman Das Naik for the Econ 8. ଆପଣଙ୍କର କୋଉଟା କି 7?
7 ମାଇ ଲର୍ଡ।
Miss Behra, I am dictating the order in 7. Just wait. You can take your seat. I thought she is appearing for the opposite parties. Mr. Radharaman Das 7. Mr. Radharaman Das Naik for the petitioner. Mr. Opposite party blank. The petitioner before this court is the husband in the marriage. The petition has been filed seeking revision of the judgment dated 17/2/2026 passed by the Lorded Judge Family Court Noyagada in CRL.M.P. number 227/2023. The said application was filed by the wife in the marriage, aged about 27 years, and the minor child born from the wedlock, minor son born from the wedlock, aged about 5 years, in the year 2023. But on कर दियो on अपनी डेट टा दे देवे। Seeking a monthly maintenance at the rate of 25,000 per month from the opposite party, who is the present petitioner. Star. The petition was favored by the Lorded Judge Family Court Noyagada, but however, directing payment of rupees 5,000 to the wife and 3,000 to the child born from the wedlock. Seeking revision of the judgment, it is submitted by the learned counsel for the petitioner that on the date of passing of judgment, that is 17/2/2026, the application filed by the husband under Section 9 of the Hindu Marriage Act seeking restitution of conjugal rights was allowed. It is submitted that once order is passed for restitution of conjugal rights, the learned Judge Family Court could not have passed order under Section 125 for payment of monthly maintenance to the mother and to the wife and the child born from the wedlock. Stop. Such proposition advanced by the learned counsel is contrary to the law laid down by the Honorable Supreme Court In the case of Reena Kumari versus Dinesh Mahato, citation wherein it has been held that when the order directing restitution of conjugal rights is passed, you had a power outage also, Mr. Naik.
My lord,
Same has happened. Actually, there was fluctuation, but they have notified not to disrupt because court is functioning. But I thought I was thinking that maybe because there was a lot of fluctuation here and then there was outage at your place. It's contrary to the law laid down by Reena Kumari versus Dinesh Mahato, wherein it has been held that direction for restitution of conjugal rights
ବନ୍ଦ ହେଉଛି
to reject the prayer for monthly maintenance. In view of the award objective of the section 125 of CRPC. Stop. It is further submitted that by the learned counsel for the petitioner that the learned court has not taken note of the evidence adduced by the present petitioner regarding his income. Perusal of the judgment indicates that the learned judge family court has taken note of the income of the petitioner herein. At paragraph 9, मेरे पारा 10, our which 3 to 74. Face mark full ଅଛି. Has taken note of the show cause filed by the present petitioner dated 12/12/2023. At paragraph 6, and 7. And discuss the evidence at page 18 of the judgment to arrive at the conclusion for determining the monthly income, monthly oblique annual income of the petitioner hearing. Stop. The learned counsel for the petitioner is apprised of the judgment rendered by the Honorable Apex Court in Samima Faruqi, Total Lecture, paragraph 19 and 20. For interfering in exercising of jurisdiction under section power of revision, this court can only go to the evidence on record as well as the pleadings which form part of the proceeding before the learned trial court. The learned counsel is also apprised, learned counsel for the petitioner is also apprised of the judgment rendered in Rajneesh versus Neha, which has laid down that the amount directed to be paid to the wife and child as monthly maintenance is akin to a money decree. Stop. In order to sustain challenge to the money decree, the petitioner sustain challenge to the amount, not money decree amount, the petitioner has to secure the same to sustain the challenge. To secure the same, full stop. Para. At this stage, the learned counsel for the petitioner submits that the learned judge family court has allowed 10 installments for payment of arrears, which comes to around rupees 2 lakhs. The installment every month from the date of judgment towards arrear till date would come to 2, 3, 4, 5, 20,000 comes to 60,000 at the rate of 20,000 per month, and the amount of maintenance at the rate of rupees 8,000 comes to 24,000. at 24,000 84,000 ଆପଣ ଦେବେ ଆଜି ଡିପୋଜିଟ୍ କରିବେ 50,000 ଟିକେ ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ ମିଷ୍ଟର ନାୟକ ପ୍ଲିଜ ଅନମ୍ୟୁଟ୍ ସିଷ୍ଟମ ଅନମ୍ୟୁଟ୍ କରି କୁହନ୍ତୁ
ଟାଇମ୍ ଟିକେ ସମୟ ଦେଲେ ଆଜ୍ଞା ହବ କାଲି ଡିପେଣ୍ଡ କରିବା ସମ୍ପୂର୍ଣ୍ଣ ପସିବଲ ହଉନି ଟିକେ ପାରିବନି
ତାହେଲେ ମୁଁ ଷ୍ଟେ ଦେବିନି
ନାଇଁ 4 ଦିନ ସମୟ ଦେନ 4 days my lord only 4 days my lord
ঠিক ଅଛି but the problem is that you are inviting this Mr. Naik. I'll direct that non-payment of the amount of rupees ଆପଣଙ୍କର 80,000 ହଉଛି actually ଆମେ ହିସାବ ଭୁଲ କରିଥିଲି 20,000 ଲେଖାଏଁ ହେଲେ 6 ମାସ 3 ମାସରେ 60,000 ଟଙ୍କା ହବ ଏରିୟର ଆପଣଙ୍କ ହିସାବରେ ବି 60 ପ୍ଲସ ଆପଣଙ୍କ କରେଣ୍ଟ ହବ 24,000 84,000 ହଉଛି so ଆପଣ ତ 40,000 କହୁଛନ୍ତି even I am but the problem will be that it will be even you cannot evade arrest ସେଇଥିପାଇଁ ମୁଁ ମନା କରେ ଆପଣ affidavit ଦିଅନ୍ତୁ the reason being now apart from the trial court's direction this will be a high court direction
my lord I'm only payable 4 days my lord only 4 days my lord for today my lord
so if it is not deposited the stay will be vacated
my lord
the petitioner shall deposit rupees 50,000 before the learned executing court where execution case number dash number ta kontu
my lord
execution case number ta
43 my lord 43 by
43 of 2026 arising out of CRLMP number 227 of 2023 disposed upon 17/26 is pending before the learned judge family court ହେଲା କଣ ସେଣ୍ଟେନ୍ସ ଟା କଣ ଠିକ ହେଲା
This for the political 50,000 before election court. There is case number 226 RICRP number. I think it is
as undertaken the deposit shall be made by ଆଜି କେତେ ତାରିଖ 21
ଆଜି 21 ମିନିଟ
so they made by 21 trial court calendar ଟା ତ ନାହିଁ ନା ସେଠି କାଢି subject to payment of rupees 50,000.
40 କହିଥିଲେ
ନାଇଁ ନାଇଁ ଆପଣଙ୍କର ଗୋଟେ ଭୁଲ ହେଇଗଲା ବୋଲି actually ମୁଁ ଚେଞ୍ଜ କରିପାରୁନି। So ଯେତେବେଳେ ଆମେ calculate କଲେ ଆପଣ 10 equal installment କହିଲେ you should have been careful also। ମୁଁ କହିଲି ଆପଣଙ୍କର discussion କରି କରି ମୋର ବି mathematics ଗଲା। 50,000 by 4 ଦିନ ହେଲେ କେବେ ହଉଛି ମିଷ୍ଟର ନାୟକ?
4 ଦିନ ଆଜି ହେଲା 21 22 23 24 25 କରିବ सोमवार आज 21 22 23 24 25 21 22 23 24 25 तारीख
by 25 ठीक ଅଛି by 25 6 20 26 the execution proceedings shall remain stayed. Failure to deposit the amount of rupees 50,000 and continuance of payment of rupees 8,000 per month for the month of June onwards shall result in vacation of this order. Copy of this order shall be forwarded to the Lorded Judge Hon'Ble Court, Nayagoda, to be kept in the records of serial MP number 227. Yes. To notice along with this order to the opposite party by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 by tomorrow. By tomorrow. Chutti padi jauchi by tomorrow. Returnable date be fixed to এটা মে লিখলে তো we paid by ଆପଣ 25 ମେ କହୁଛନ୍ତି ନା?
माइलर
26 ମେ କରିଦେ 26 ମେ returnable date be fixed to 25/6/2026. The matter shall be listed in the week commencing 6/7/2026.
माइलर
जो एंट्री मॉडल टा आईआर एनएस एकाठी टका है स्प्लिट कर आइए 212/2026 had noted counsel for the petitioner. He reiterates his submissions as noted above. As an interim measure, subject to purada likhi devo. It is directed that so yes. Yes.
Item 9.
Miss Behra, you're asking. Nine रे पढ़े थिले ना से पढ़े ले Nine, Mr. Have you been short copy, Mr.
Yes, this is soft copy.
Mr. Ray, Mr. Tripathi?
My lord, item 9.
Again.
The corporation arrayed as opposite part number 4 and no copy has been served on me.
Pass over kariyo na kon kuade gale item 9. Apana ochandi madam?
Again, sir.
Yes, please.
After
Apana na madam? What's your name, madam?
Yes, Acharya.
MS S. Acharya for the petitioner.
Kindly taken
Mr.
vacation.
Mr. Prem Kumar Mohanty, Additional Standing Counsel for OP 1, 2, 1, 2, and 3. Sir, Mr. Ray and Mr. Mohanty, Insurance Medical Officer, ESI ki appear karibe apano?
1, 2, 3 and 5. Mr. Mohanty.
Acha, then ठीक है. 1, 2, 3 and 5. Prem Kumar Mohanty, Additional Standing Counsel. Mr. Amarendra Prasad Ray, Standing Counsel. OP4. Stop. The learned counsel, the matter being listed for fresh admission, adjournment is sought for by the learned counsel for the petitioner. Copy of the lead application has Mr. Mohanty. Have you received copy?
Yes, I have received copy.
Copy of the writ application having been served on the Lord Additional Standing Counsel, he appears and waives notice on behalf of 1, Tier 2, 3 and 5. Hello. One extra copy, Mr. Ray Habo. One extra copy of the application shall be served on the Lord Standing Counsel, who usually appears being present in court. He shall accept notice. Yes, madam, dispensation of page केमती ही परिवार गया। आइए केमती ये की प्रकार आइए फाइल कोले।
ସେଟା ଭିଜିବଲ ନଥିଲା ସେଟା ଆବଶ୍ୟକ ନାହିଁ।
Dispensation नहीं परिवानी। सिंपली किसी रूल नहीं हाई कोर्ट रूल है जब आप फाइल करिए तब पर कोई वजह पेज फाइल करिए नहीं। Either you file or do not file, that's a choice. But after filing, you cannot say that. Dispensation कौन होगा ये?
A copy is not there, my lord.
Say, Mr. Mahanti use the paperless.
No.
अपन तो भिसी रे अचंती कोर्ट येटा रिजेक्ट करे पड़ियो मैडम I cannot pass a order for dispensing to file legible copies. आइए 1664 of 2026 flag A Mr. Mahanti flag A click कले सेठी के नांती अपन असिस्ट करे प्रज्ञा मैडम ने किया अछंती पुरा ना
ବର୍ଷା
I'm sorry वर्षा मैडम अछंती say the IA 1664 the IA has been filed for dispensing with the filing of legible copies legible pages 39 43 45 47 62 89 and 101. The Lord AC submits that copy of the IA has not been served. In any view of the matter, as per the High Court rules, the petitioner has to file legible copies of the pages to be taken on record once the application is filed, enclosing those pages. Accordingly, the prayer for dispensing with filing of legible copies cannot be granted. The petition is disposed of. आपण नीट टाइप कॉपी नहले सर्टिफाइड कॉपी केतेटारे सर्टिफाइड कॉपी नहले नीट टाइप कॉपी हेले भी हबो सपोज आपनकर देखा जाउनी जेरक्स नीट टाइप कॉपी देबे आ डिस्पेंसिंग कोन फाइल कर देले यस नेक्स्ट प्लीज द मैडम केबे आसीबो कहउछन्ती
Maybe after vacation. After vacation.
जेबे भी हेले चलिबो आपण डेट करंतु
council 27
as prayed for by the Lord Council for the petitioner, the matter shall be listed for fresh admission in the week commencing. It order says actually. Now for fresh admission in the week commencing 27 26 you saw aji oda copy diyo to standing council को
हाँ जी दे दो सकाल
जो लिख लेनी copy shall be served on the standing council within 2 working days कर दूँ through. Yes.
item 10
Mr. Pushpala.
May I please, Your Lordship?
Item 10, my lord, I am appearing through virtual mode. I am on caveat. Copy of the writ petition has not been served on me, my lord.
Mr. Pushpala का आपण system पड़े गला आपण को mobile में appear करेगी. आपण computer पड़े गला.
सटे खराब होची.
फोटो खराब है गला.
आंध्र मोर से limited prayer, Your Lordship.
But caveat has to be discharged. काली ऐसी हो.
In fact, there is no interim application.
Caveat दिले अब तो you have to discharge the caveat. Interim order होगा कि नहीं होगा कहता. It has to be heard. But caveat has to be served.
Milords, आंध्र गोटे
काली ऐसी हो serve करीबे. ना after vacation.
मुसरे काली सर्व कर दोसी vacation विते निया जाऊ नले.
नहीं vacation मुझे direction देवी नहीं. नहीं सीटा ही परिवार नहीं because it's a separate bench.
In fact, there is no IA to the writ, so therefore there is the matter can come up after vacation, my lord. I'll take
next. Let Mr. Pushpala say.
Election issue, Lordship. Election of the office bearers, Lordship. Election has already been completed since 21/12/2025, Lords. as per the notification dated 10/11.
তাহলে ସେମାନେ ତ ସେ ବୋଧେ Mr. Roy must be participant.
Yes, my lord. It has
Candidate
already been notified. I'm the elected secretary since 25.
ସେ ତାହେଲେ ସେ ସେଥିପାଇଁ କ୍ୟାବିନେଟ୍ ଫାଇଲ୍ କରିଛନ୍ତି।
ଆଜ୍ଞା ମୋର
ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ସାର୍, ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ହିୟରିଂ
ଆଜ୍ଞା
ଆଜି ସର୍ଭ କରିବେ, ପାସ୍ ଓଭର କରିବା। ଅବଶ୍ୟ ଆଜି ଅଛି, ଆଜି 2:45 ଆଜି ରେଫରେନ୍ସ ଅଛି
ସାର୍।
ନହେଲେ କାଲିକି ଆସିବ।
ସାର୍ ନା ତାଙ୍କୁ କପି ଦେବାକୁ ପଡ଼ିବ ତ ଆଫ୍ଟର ଭ୍ୟାକେସନ ଆସୁ ସାର୍, ମୁଁ ତା ଭିତରେ କପି ସାର୍ ଦେଇଦେବି।
ସିମ୍ପଲି ଆଡଜର୍ନ ଆପଣ ଯଦି ଭେକେସନ ରେ ଚାହିଁବେ ସେ ଲିଷ୍ଟ କରିବେ। ଠିକ ଅଛି। So Subhash Chandra Puspalaka for the petitioner, Mr. Prem Kumar Mohanty. Mr. Mohanty, you are here. 10.
Yes,
or
I am
Mr.
here.
Lenka.
I'm here.
Lenka,
I'm in
Mr.
this
JJ
case.
doesn't like virtual court or what? Mr. Prem Kumar Mohanty, additional standing counsel.
One man.
For OP 1. No, I have not got the file. I'll get the file. Just give me a second. ଆପଣ ଷ୍ଟେଟ୍ ବ୍ୟାଙ୍କ ପାଇଁ ମିଷ୍ଟର ରୟ?
No, I'm for.
No, my lord. I am for the association.
ଆଚ୍ଛା Mr. Puspalaka, association is not a party.
No, my lords, association not a party, your lordship. My entire grievance is against the election officer, your lordship.
Okay. The OP1 blank, OP2 blank. A caveat has been lost to Lorded Counsel, Mr. Rajit Roy, which is tagged to the brief, which is tagged to the file. Stop. The Lorded Counsel for the petitioner shall serve copy of the application on the caveator. The matter is adjourned. Liberty to mention. Bas.
Milord, diplomatized plus. Milord.
ଆପଣ କେତେ ଦିନରେ ଦେବେ?
Sir, मुझे दिने दे देवी sir.
May I pray?
3 days.
Let it be taken up after the reopening week, my lord, because I don't think so. My learned friend is showing any kind of urgency, and he is also, in fact, saying that.
Why should I adjourn? When he's not moving, I mean, it is his choice, petitioner's choice. He may move, but I can't direct before listing before the vacation court because it's a different bench.
No, I'm saying that probably my learned friend does not have any objection if it comes after vacation. If that's the case,
No, I have objection. I have objection, Milord. It's an election issue.
You start copy within 2 days or 3 days, Mr. Puspalaka.
Plus 3 days, Milord.
Within 3 months.
Milord.
Grateful, my lord.
Yes, please.
Milord.
11 caveat petition number टा लिखिली. Caveat petition number 592/2024. Well, देखिए लिख देवे.
Milord.
That has been tagged. Yes.
Milord.
11 Mr. Misra.
Milord.
Mr. Misra, kindly turn to take the left or the right because that pillar is there. So, ଆପଣ ଟିକେ ବାକି ଡାହାଣକୁ ପଳେଇ ଆସନ୍ତୁ। ହଁ। ଯୋଉଟା ହେଲେ ବି ହବ। Yes.
Again.
Yes, please.
Lord. I am challenging the initiations of the proceedings on the questions of. Lord, I have filed the writ application challenging the initiation of the proceeding under section 25 of the Guardianship and Wards Act, as the court in the sessions has to know the jurisdiction at all, as has been conferred under section 9 of the Act. That is the reason why I filed.
Mr. Misra, that has to be decided by the court. It can't be decided by the appellate court.
No, this is not the appellate court, my lord. I am not here for the appellation.
Or
The fact remains
227
clear.
court. 227 court. 227 court cannot decide ipso facto on its own without the matter being adjudicated by the court of which the jurisdiction is challenged.
May I submit, my lord?
So one thing is that suppose you say you do not have a jurisdiction, the court decides against you or in favor of you.
Yes.
That's a different thing. But this can be raised in a 227 application.
May I submit only one line, my lord?
Please.
My lord, if the court is not competent, as the power has not been conferred upon the court, then it is an abuse of process of the court.
Sir, that cannot be a matter of
Question
speech.
is that, my lord, the question is.
Misra, if you apply those tests, then this is an abuse of process of court. The reason being, the court of which jurisdiction you are challenging, you have not approached. I
Lord,
cannot
your
second
lordship,
guess.
kindly see for-
Mr. Misra, I cannot second guess. If the question is raised, what would be the response of the court? So now this process becomes a complete abuse of process of court. Because High Court, without any cause of action, is entertaining a writ petition under 227.
My lord, here is something different, your lordship.
It's not different. It is absolutely on the point.
May I invite your
When-
lordship's attention first?
No,
The
no,
section,
sir, please answer, then draw attention. Have
Yes.
you drawn the attention of the court before which it is filed that that court doesn't have jurisdiction, and what is the response?
I
Or
have
you are
not,
raising it for the first time by invoking 227 before this court.
yes. I
So
have
that-
not
that is
raised
that-
this question. I
so
have
that
not
is
raised
abuse.
this question
So this
before
is
the
the-
London trial court.
So this is what is called abuse of process. What
My
you
lord,
are doing is abuse of the process. And suppose now, even let us assume the court assumes jurisdiction, that court. It is illegal order. It can be challenged also. And this is
Can be
a,
challenged. Your lordship is correct. It can be
no,
challenged.
I may be wrong. I may be wrong, but this is one thing I am sure that this is abuse of process of court.
But
Because
the-
you are coming to High Court, raising a grievance against a court which has never heard you.
Yes.
So how I will form an opinion, Mr. Misra?
My lord, my submission is that section 8 and section 9. May I permit
But I
you
am-
to say?
Mr. Misra, I am presuming, I am accepting your contention. My problem is not that. I am accepting your contention that the court doesn't have jurisdiction. Even if I accept that, how can I proceed without that court answering that? That is the question to you.
One thing I can develop, my lord, and your lordship can be developed that the invoking the jurisdiction 226. My lord, the court lacks the jurisdiction. I am at Hyderabad, the minor child is at Hyderabad.
You are imagining.
Without any basis, I will
You are,
come.
you are building, Mr. Misra, you are building a castle in thin air. It is worse
No.
than that. You are saying the court doesn't have jurisdiction, but you come to High Court to tell that, not to tell that court. That's the question put to you. You are telling so many things. So you are being asked, when did you bring this to the notice of the court, which is proceeding without jurisdiction? Then you are giving a speech. You have to show that pleading that before that court you have raised this question, not been
No, I have
answered.
not raised that question. I
So
have
then
just
how can this court
appeared
proceed
and-
then?
My lord, I have simply appeared there.
Unless that court adjudicates that issue, because section 9, if you look at read section 9 CPC.
Section 9?
CPC. And the section 9 and 45 of Guardianship and Wards Act.
Section 9 of the Wards Act.
CP ଆଗ CPC ପଢନ୍ତୁ।
I have not that CPC, my lord, just now.
ସେ ସାମ୍ନାରେ ନେଇ ଆସନ୍ତୁ କଣ କରିବା ଆଜି ତ ନାହାନ୍ତି କେହି ସେଠି ଆଉ ମିଷ୍ଟର ପଟ୍ଟନାୟକ CPC ଦିଅନ୍ତୁ।
After vacation issue, I will brought to that.
ମୁଁ ଆଜି ସମୟ ନଷ୍ଟ କରୁନି। ଆପଣଙ୍କର ଆଡଭାଣ୍ଟେଜ ଆପଣ ଆଜି କଲେ ଆର୍ଜନ କଲେ ମୋର ସେ ଆଡଭାଣ୍ଟେଜ ନାହିଁ। I have to record reasons.
My lord, the question is there. Section 9 of the CPC, what I remember.
ଆପଣଙ୍କ point ତ ମୁଁ ଯଦି
All the civil court has the jurisdiction to try this
ଆରେ
suit.
ମୁଁ ତ accept କଲି। I accept that the court doesn't have jurisdiction. Because even I do not know what the other party will say. Still, can I say that the court will not try it? Do I have the jurisdiction on 227, 227?
My lord, so far section 9 of CPC is concerned, my lord. All the courts have the jurisdiction to try this suit unless expressly or impliedly barred under the provisions.
So
That's
now,
what I recollect that
let us
case.
assume
My lord,
that
that
this court, family court, Bhubaneswar doesn't have jurisdiction. So who will tell?
family
High
court
Court will
is
tell them.
established, my lord, and the jurisdiction under section 7 of the act itself.
Mr. Misra, you are either avoiding or evading the question.
No, I am not
Because
avoiding.
I have told you,
Well, I
I
heard.
accept your contention. So why you are arguing? Why you are laboring on that? I accept your contention that the family court at Bhubaneswar doesn't have jurisdiction. But without that court being told by you, I will tell. Should I identify myself with a litigant?
Pardon?
ସେଇଟା ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ଲିଟିଗାଣ୍ଟର କର୍ତ୍ତବ୍ୟ କୋର୍ଟକୁ କହିବେ ଆଜ୍ଞା ଆପଣଙ୍କର ଜୁରିସଡିକ୍ସନ ନାହିଁ ହାଇକୋର୍ଟକୁ ଆସିବେ 227 ଫାଇଲ କରିବେ ସେଥିପାଇଁ ମୁଁ ସେଠି ଫାଇଲ ଆଇ ୱିଲ୍ ଇସ୍ୟୁ ଏ ଡାଇରେକ୍ସନ
Lord, jurisdiction conferred is under the act itself.
Excellent. So you have to tell that court.
But the question, my lord, if
Tapore
he will
apon kohibe
appear
after
and
vacation.
say, if he will appear and say the jurisdiction, it will take the entire abuse.
Sir,
Because
this is,
when there
sir,
is
this,
no,
sir, this is abuse of process. That you do not go to the court to tell, but come to High Court to tell High Court. That is what is abuse is. Then why you have come to High Court? High Court has invited you.
pardon?
Have you come to High Court on invitation or on your own volition?
I'm unable to understand, my lord.
अरे आपण जो हाईकोर्ट को आसिले हाईकोर्ट को आपण निमंत्रण देले ना आपण फाइल कले केसटा सो यू कैन टेल द कोर्ट देयर
Pardon?
आपण हाईकोर्ट को जो आसी कहउचंती जे से कोर्ट रो नाही जुरिस्डिक्शन सो
आज्ञा।
से कोर्ट रे जो कहू नांती काहे जे कहू नांती कोर्ट रे
Well, then what your lordship is to that extent, I have to file an application under order 7 rule 11 to say that you have.
आपण केमिति करे दैट आई एम नॉट आस्किंग द वे यू हैव कम टू हाई कोर्ट एंड फाइल एप्लीकेशन रिट पिटिशन आपण फाइल करचंती
Again.
stating that that court has a you are seeking a declaration here.
Yes.
So what about that court? The High Court will second guess that. Before which court the point of jurisdiction is to be raised?
Either before the, my lord, the original court, because here the process that the law is, there is a provision under the act.
Sir, there is no concept of raising it before another court before that court takes up that issue. It cannot be.
My lord, the question is section 9 is to be applied here.
I will decide who is the plaintiff and who is the defendant there. I will decide that whether the court has a jurisdiction or not. So that is what abuse is. You are abusing. The application under section article 2.
Well, lordship may adjourn for after vacation, I will satisfy.
Yes, I'm really kind to adjourn. No difficulty, but I can't waste my time after listening and discussing this.
Because
that would also amount to abuse of process of court. Because a petition is pending, you do not appear there. You come because you decide to come to High Court, so it has to be adjourned or what? It will be adjourned definitely because you are not answering. You are answering everything but not telling why you are not going to that court. And whether coming to High Court by not informing the other court is abuse or not. The application filed before this court is by the petitioner who claims to be
father and mother.
Father of the minor child.
Father of the minor child.
Father of the minor child whose custody application is filed by the
father-in-law and mother-in-law.
Application na kai?
Annexure 1, my lord, that is, sorry. That is Annexure 5. By the father-in-law and mother-in-law.
Filed by the grandparents, the maternal grandparents before the Learned Judge Family Court Bhubaneswar. In civil proceeding number 819 of 2025. Apparently, after filing of the application, the present petitioner has been issued notice having been arraigned as defendant in the proceeding before the trial court. It is contended by the learned counsel for the petitioner. It is contended by the petitioner as submitted by the learned counsel that the Learned Judge Family Court does not have jurisdiction to try the said CP filed under Section 25 of the Guardians and Wards Act. The learned counsel for the petitioner is apprised of that if the Lauded Court, Judge Family Court 1, Bhubaneswar does not have jurisdiction, which comes to a mixed question of fact and law, the state court has to be apprised of the said fact by the present petitioner who has been arraigned as defendant, respondent number 1, and his wife. से वाइफ ताकर मदर नुहति ना कोन
Pardon?
सरोजिनी राउत कहार मा छुआर मा ना नुहति
Second marriage.
and his wife who is not the mother of the child, as she is the as the petitioner has married for the second time. The petitioner has married her for the second time. First wife karo kon hala?
First wife expired in the father's house due to COVID-19.
The mother of the child, that is first wife of the petitioner, having passed away. Stop. In considered view of this, it is submitted by the learned counsel for the petitioner that the filing of the petition for custody of the child at Bhubaneswar would amount to abuse of process of court, as the learned court doesn't have jurisdiction. But in considered view of this court, jurisdiction conferred by statute, that is Guardians and Wards Act, Section 9, as well as Section 9 of the CPC, would indicate that the said court has to be apprised by filing proper application and the decision has to be taken. This court, by exercise of power under Article 226 and 227, would not be in a position to appreciate the facts without the same being considered by the learned judge family court and without the court having formed its opinion regarding the contention of the petitioner, who is the respondent before the state court, that the court doesn't have jurisdiction. The petitioner has adjournment. The matter shall be listed for fresh admission in the week commencing 6-7 Mr. Mishra.
Second week race. First week July might not be available.
So 6-7 in fact second week. Ek ho first week. In the week commencing 13-7.
Again.
In the week commencing 13-7 2024. अपन जदि सेशंस ट्रायल होता मे बी सेशंस कोर्ट अपन कहले सेशंस कोर्ट को जुरिडिक्शन नहीं, बिकॉज़ इट्स नॉट ए फैमिली कोर्ट. दैट्स अ डिफरेंट थिंग. एनीवे, रेस्ट ऑफ द मैटर्स आफ्टर रिसेस will resume at 2 p.m. Any mentions made to be made by any learned counsel?
Lord, 136 item may not be reached because the court...
Page wise, page. Mr. Mishra, kindly wait. Page wise जाऊँ चाहिए मैं. Page 2 रे की को mention करचो दी करो.
Item 17 नहीं man. Item 17 after vacation.
आपन को ना सर गोखा बेरे तो ना थी 17
डी प्रधान दैसे प्रधान
मिस्टर डी प्रधान 17 लिखंतु. मिस्टर डी प्रधान फॉर द पिटिशन. The matter is listed for 17 listed for fresh admission and is mentioned by the learned counsel for the petitioner seeking adjournment Accordingly, the matter shall be listed in the week commencing 6/7/2026 for fresh admission. Yes, Mr. Misra, you are mentioning
36 item. It is.
36 for after notice.
Milord.
ସେ ତ ପହଞ୍ଚିବନି ଆପଣଙ୍କର ଆଜି ତ ରେଫରେନ୍ସ ଅଛି ନା ଆଜି କେତେବେଳେ
After vacation, any date, my lord, 13th.
36 ର ଅଦର ସାଇଡ୍ ଅଛନ୍ତି
Other petitioner might be there. I am for
ଠିକ ଅଛି
the
ନୋଟ୍ କରୁଛୁ ଆପଣ ନୋଟ୍ କରିଥାନ୍ତୁ ଲାଷ୍ଟରେ ଦେଖିବା କେବେ ହେଲେ କେବେ ଯାଉଛନ୍ତି
13th July ରେ ଆସୁ ନହେଲେ
ସେ
ତାପରେ
13/7 ୱିକ୍ କହୁଛନ୍ତି ନାଇଁ ଆଫ୍ଟର ନୋଟିସ୍ ଟା ସେତିକି ରଖନ୍ତୁ 13 ରେ ଆପଣଙ୍କର ଅର୍ଡର୍ସ ଅଫ ଫ୍ରେଶ ଆଡମିସନ ରଖା ହଉଛି 20/7
ଆଜ୍ଞା
subject to I mean the the Lorded Council saying anything something else.
Yes, sir, lordship.
Yes. Mr. Misra, Manojan Misra.
37 item.
देखिए we'll try to देखिए after recess ना अपन adjourn करेंगे ना take up
Yes, after recess में
देखिए let us see how far because there is a truncated we'll resume at 2. Mr. Yes.
Item 20.
Yeah.
Item 27.
Satish.
Orders item.
27 टा की मेंशन करते लगे
27 I am the petitioner.
हाँ कहले ना काउंटर पे कौन दिया है नहीं कहले स्टेट रो मु पचारली ताकू कहले से कहले प्रभु अछंती बोली सतीश रे प्रभु अछंती बोली
My lord, I am there. Sorry. 26. Item 26. Sagarika Mahadeep.
26 ऑर्डर से 26 था अच्छा
Mile.
कौन चाहते सर
ना amendment petition ना amendment में भी amendment पर
बट ऑर्डर पास करिया पड़िबो
Mile.
सो आपन को ना सर
भवानी सामल.
ठीक अछि देखिबा आफ्टर आई रिज्यूम देन आई मे पास दैट ऑर्डर
Yeah, mile.
Because I am not taking out of turn. Hello?
Mile.
Yes.
Mile.
Item 12. What we can do is that since we have to rise at 2:45 because of the reference, so we can continue till to say another 15 minutes for the regular, then we can take up the mention if we do anyone mentioning. 12, sir.
Yes, may I please, lordship.
Mr. Rituranjan Chotra.
Yes, lordship.
Emperor.
Here the petitioner.
Anyone appearing for the opposite party?
The petitioner challenges this order dated 29/4/2026.
Yeah.
Rejecting the prayer of the present petitioner filed by the present petitioner on 21/4/2026 to set aside the order dated 13/3/2026.
13/3/26. So what is the order?
Yes, 13/3/2026. I have annexed your lordship. That is page 18, your lordship. Page 18. The petitioner is the present along with
You should have flag marked it. Separate annexure kari nahanti.
No, your lordship. Page 18, your lordship. Annexure 2 series. Respondent is absent on repeat. No one present on the side of the respondent while the matter was taken up for hearing.
13/3.
13/3/2026. Also page 18.
पूरे मूल रूप पढ़ो तो petitioner is present along with counsel.
Along with his counsel and filed hajira
Respondent is absent on repeated calls. No one is present from the side of the respondent while the matter was taken up for hearing. Respondent did not adduce her further evidence despite of several opportunities given to her. They also she failed to do so. Hence, the further evidence respondent is closed. One petition on behalf of the respondent praying for correction of the correct hearing of the. Here, let's see. Here, the further evidence of the respondent is closed, and the evidence was closed, and for which the respondent filed a petition to set aside that order, your lordship. The respondent wants for further evidence from her side, so that was rejected.
The petitioner is the respondent wife.
Petitioner is the respondent wife, and the opposite party is the husband. He filed for a divorce petition, your lordship.
The learned counsel standing beside you is representing. This is
glance to page 24 only. Page 24, annexed 2, have a glance to that.
24 actually मोर मैच कोनी 24 अपन कोन देखिया चाहउछंती
24 not see 23 the order annexed 2 minute
28 2 24 26 टा adjournment एटा तो
मतलब
so far the petition to set aside the order dated 13/3/2026 is concerned
24 page to running page 24 madam
पढुनांती खाली 24 पेज कहउछंती पढुनांती so far the petition to set aside सेटा पढुछंती
so far the petition to set aside the order dated 13th March 26 is concerned. It is pertinent to mention here that the evidence of the respondent was closed on 28th February 24. Since thereafter the respondent was given 26 adjournments.
Right.
And her evidence was closed after almost 2 years on 13th March 26. Hence, in the present circumstance, I am not inclined to recall order data so and so. Then where the wrong?
Let's see. I have on 28 to 24. How these lordship, it is not stated this like lordship, how this order is given by the learned family judge, but in 28 to 24 lordship, just today I have scanning the order, that was no it was the false that the evidence of the respondent was closed. It is false. Nothing was mentioned on that day. That order, the case record is posted today for further cross-examination of RW1. The petitioner is absent, whereas the respondent is present. However, counsels for both.
It may be a mistake. So, according to you, when the evidence was closed?
Your lordship, 13 26 रे क्लोज ता पूर्व डेट रे हजूर पिटिशनर थिला
because I have also read that, so in fact you
evidence update भी देछु
for the opposite party sir आपन नाटा कोन कहले your name sir Mr.
एलन पटनायक
ठीक है माइक्रोफोन भी व्यवहार करो माइक्रोफोन ने ठीक बोल
ललित नारायण पटनायक
Mr. Ellen Patnaik, just look at the order where just now we read. That is that आपण पेज मार्क टिके एपट सेपट अछि, but it says that आपण जोटा 13/3 पूर्व ऑर्डर ता पढंतु
24/2/2026.
Yes.
Both the parties are absent. However, counsels for both the parties are present. Counsel of respondent seeks for time. Time is allowed. However, put upon 13/26 for further evidence from the side of the respondents.
So, आपण affidavit दियंतु. आपण गोटे affidavit दियंतु जे आपण जो दिन appear करिवे এবং continuously till your examination is completed, you will not take adjournment.
Yes, lordship.
And Mr. Patnaik,
My lord,
Mr. Patnaik, please appreciate if you get a walkover,
will
your
your
client's
lordship be kind
interest is
enough
not
to hear me
satisfied.
just a moment? My lord, will your
Arey,
lordship be kind
after hearing you for 5 minutes, can I not ask you something? I'm asking you. You are under a duty to answer.
Sir, my lord, his evidence is no more required. He is not the respondent. He is the brother of the respondent wife. What evidence required?
Yeah, I have filed the evidence affidavit in the court, your lordship.
Today, I don't know. Today, 2-3 matters have been argued like this, as if I am the trial judge. This question, Mr. Patnaik, with your experience, this question, whom you are to ask? The High Court in revision or writ or the trial court?
No, trial court is there to.
So you raise that plea. Whether you examine or you do not examine. So you must read the order. I cannot read between the lines. Kindly read the order. 13.3 order.
My lord, what happened, my lord? 19 cases has been lodged against me.
अरे आपण पढ़िबे ना पढ़िबेनी आगर कह करंतु पढ़िबेन जदी कहबे मु पढ़िबी. Let us not waste time like this. Our 5 मिनिट रे केस सरतानी आपण पढ़ंतु. 13.3 order टा आपण पढ़ु नांती मिस्टर पटनायक.
Sir.
अरे आपण जदी म्यूटेड पढ़िबे केमति हो हाउ डू आई नो आपण के पार्टी करी पढ़ंतु कोटा आपण कहउचंती सो दैट यू विल अंडरस्टैंड द पर्पस एंड टेनर ऑफ द ऑर्डर.
Till date, sir, I have not received the copy of the. My lord, got it. Petitioner is present along with his counsel and file has a respondent absent on repeated calls. No one is present from the side of respondent while the matter was taken up for a hearing. Respondent did not adduce her further evidence despite of several opportunities given to her. They also.
Slowly पढ़ंतु. आपण ता कहलेन जे ब्रदर कोर्ट तो कहउनांती ब्रदर. कला सरीला.
Respondent did not adduce her further evidence despite of several opportunities given to her. They also failed to do so.
Failed no आया failed से भी भूल आपण भी भूल पड़िबे. Failed. They failed to do so.
हाँ. Failed.
Hence the further evidence of respondent.
Further evidence of respondent is closed.
आपण कहउचंती से ब्रदर. How can I read between the lines? I'll add that word. लिखा है brother of the respondent is closed or say PW or DW लिखा है. So what your point is well taken, Mr. Patnaik, that he was seeking too much of adjournment. But now the problem is that earlier order does not reflect so when it was put for, but that order where it was closed is not placed before me. 24/2/24 order.
This petition was filed by the wife as a vexatious petition. That is the correction of the first title.
Trial करिबी की vexatious करी की आपण petition dismiss करी की allow करि परिबी की. I don't know what is this habit of arguing something which is not subject matter of the
my humble assumption before your lordship.
Vexatious आपण जो कहउचंती I am impressed. आपण गोटे बढ़िया वर्ड कहले vexatious. Can I do that? Pass that order. अरे I will now observe. Suppose let us assume I will observe that a petition filed by the wife is vexatious, so he cannot be granted time. Can I do that?
No.
अतल काई सेडा कोन को हमर समय के नष्ट करिबा सर. Sir, let us be specific because I see I don't know. It's civil litigation. Lot of time is wasted in arguing, which is not the point to be considered.
Right.
RPFM ho. Even it was argued that the court doesn't have jurisdiction. I'll pass a order on that because I have to make a trial then.
But
बर्तमान vexatious धरे पे can I try the suit here? I cannot. You have to address the issue whether by this order, existing order, where the respondent's evidence has been closed. Maybe technically it is right, but you must, Mr. Patnaik, you must understand. These kind of orders by the court is very vulnerable. Because this plea will be taken before this court. Now maybe not writ appeal, but it will be carried to Supreme Court. These kind of orders are always very vulnerable when they don't grant opportunity. It will be wise on your part that he should undertake now, file affidavit,
The
yes ଆପଣ so ସେଟାକୁ ଆପଣ ଶୁଣୁ ନାହାନ୍ତି ବୋଲି ଆଲାଉ କରୁନାହାନ୍ତି ମତେ କହିବା ପାଇଁ। I am not against you। ଆପଣ କେତେ ଦିନରେ ଏଭିଡେନ୍ସ ସାରିବେ, ଏଭରି ଡେଟ୍ ରେ ଆପିୟର କରିବେ, ଆଫିଡେଭିଟ୍ ଦେବେ, ଆଜି ଦେବେ?
ମୁଁ ସାର୍ କଣ ସିଏ ଦେବେ ନା ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ୍ ଟା?
ଆରେ ଆପଣ ପ୍ରୋବ୍ଲେମ ଅଛି ସାର୍ ପଟ୍ଟନାୟକ ସାର୍, ମୁଁ ଆପଣଙ୍କୁ କହୁନି ସାର୍, ମୁଁ କହୁଛି ଆର ସାର୍ ହଉଛନ୍ତି ମହାପାତ୍ର ସାର୍।
Sir, ଆମେ affidavit ଫାଇଲ କରି ଦେଇଛୁ। Only
Sir, without
this is item କେତେ?
item
Mr. Chotrae,
12 years.
Mr. Chotrae,
Yes, yes.
ମୁଁ ଯେତେବେଳେ ଆପଣ କହୁଛି please don't misunderstand, I am addressing Mr. Chotrae, not Patnaik। So ଆପଣ affidavit ଫାଇଲ କରିଛନ୍ତି, କପି ଦେଖାନ୍ତୁ।
Evidence affidavit ହଜୁର ଆମେ ଫାଇଲ କରି
evidence affidavit again ଆପଣ Mr. Patnaik ଭଳି ଆରମ୍ଭ
କୋର୍ଟ ରେ
କରିବେ।
yes yes lords।
ଆପଣ କୋର୍ଟ ରେ ଫାଇଲ କରିବେ ଯେ I will undertaking that you will appear on every day and will not seek adjournment।
yes yes lords।
yes ତ ସେଟା ଆଜି କରିବେ?
କାଲି yes କାଲି
kindly discuss with Mr. Patnaik, both of you guide the litigation। you are sufficiently experienced and senior। ଆପଣ ଯୋଉ ଦିନ appear କରିବେ ସେଇ ଦିନଠୁ କୋଉ ଟର୍ମସ୍ appear କରିବେ, file not a lengthy affidavit, one paragraph। I hereby undertake to appear on such date, when the matter will be taken up, evidence I will adduce evidence।
yes
it will be continuously done, even required on consecutive dates।
yes yes
I will fully cooperate।
yes yes lords।
May I pray your lordship one thing?
Yes please।
My lord, the wife has adduced her evidence. Now the turn of her brother। if he
ଆଜ୍ଞା ଶୁଣନ୍ତୁ, ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ସେଟା ଠିକ କଥା କହୁଥାଇ ପାରନ୍ତି ଆପଣ, କିନ୍ତୁ ଲାଙ୍ଗୁଏଜ ଟା ଦେଖନ୍ତୁ ସାର୍। ସେ କହୁଛନ୍ତି ଏଭିଡେନ୍ସ ଅନ୍ ବିହାଫ ଅଫ ଦ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଇଜ କ୍ଲୋଜ୍ଡ। ସେ କାହାକୁ ଏଭିଡେନ୍ସ ଦେବେ? ମୁଁ ତ ତାଙ୍କୁ ଡାଇରେକ୍ସନ ଦଉନି ଯେ ତାଙ୍କର ରିକଲ ହେବେ ବୋଲି।
right sir।
ଆପଣ ଯେତେ ତା ଭିତରେ ପଶିବେ ସେତେ ୟୁ ସୁଡ୍ ଆଭଏଡ୍ ଦୋଜ ଥିଙ୍ଗସ୍ ରାଦର। ସେଇଟାକୁ ଆପଣ ଛାଡି ଦିଅନ୍ତୁ ଟ୍ରାଏଲ କୋର୍ଟରେ। ଆପଣ ଧରନ୍ତୁ ସିଏ ଆଉ ଥରେ ରିକଲ ହେଇଛନ୍ତି କି, ସେ ତାଙ୍କର ଏଭିଡେନ୍ସ ସରିଲା ପରେ ସେ ରିକଲ ହେଇଛନ୍ତି କି? ମିଷ୍ଟର ପଟ୍ଟନାୟକ
ତାଙ୍କର ସରିଛି ଏଭିଡେନ୍ସ, ସରିଯାଇଛି।
ରିକଲ ହେଇଛନ୍ତି କି?
Pardon?
as a witness ରିକଲ କରାହେଇଛି କି ତାଙ୍କୁ?
I have been recalled। The husband has been recalled several times।
ତାଙ୍କୁ ତ କରାହେଇନି, ତାହେଲେ ଆପଣ ଏଟା କାହିଁକି ଆପ୍ରିହେଣ୍ଡ କରୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି।
ସାର୍
ଆପଣ ଯେତିକି ଶୁଣନ୍ତୁ, ଆପଣ ଡୋଣ୍ଟ ଏକ୍ସପାଣ୍ଡ ଇଟ୍। ଏକ୍ସପାଣ୍ଡ କଲେ ଇଟ୍ ଗେଟ୍ସ କମ୍ପ୍ଲିକେଟେଡ। ସୋ ହୁଏଭର ଇଜ ତାଙ୍କ ଏଭିଡେନ୍ସ ସେ କଣ କରିବେ, ଲିଭ୍ ଇଟ୍ ଟୁ ହିମ୍ ଅର ହର। ଆପଣ ଅବଜେକ୍ସନ ଦେବେ।
my humble submission is they have taken adequate times। Only 26 adjournments they have taken, but their evidence is no more required to the proceeding। I am not denying the marriage। what her brother will say, my lord।
ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ହେଲା ଆପଣ 13(3) ପଢିଲେ, ସବୁ କଥା ଆର୍ଗୁମେଣ୍ଟ କଲେ, but you are not sticking to 13(3) order। 13(3) order is under challenge।
yes
regarding whether how much evidence she will tender or whether she will be recalled, that is not the issue। am I directing that?
no।
ଆପଣ 13(3) order ଟା ତ ପଢିଲେ, ଥରେ ଦିଥର ପଢିଲେ, then you became conscious that there is no such observation regarding anything। so regarding 13(3) order, she will file the affidavit that you see 13(3) the court has observed that she doesn't cooperate and appear।
yes
no my lord।
so no my lord,
no more required। only my lord, her brother is to be appear before the court and adduce the evidence।
again I cannot say that her brother will appear। you must understand that will be order against you, because that is not the subject matter। that will be challenged in Supreme Court or wherever, that's a different thing। ଆପଣ 13(3) order ଟା ଆଉଥରେ ପଢନ୍ତୁ। it does not deal with anything like that।
sir I do admit, but
ଆପଣ କାହିଁକି ସେଥିରେ ଆପଣ କାହିଁକି ତାକୁ ଏକ୍ସପାଣ୍ଡ କରୁଛନ୍ତି? I don't know what is in your interest। ଆପଣ ସବୁବେଳେ ଆପଣ କ୍ଲାଏଣ୍ଟ ଇଣ୍ଟରେଷ୍ଟ ଦେଖିବେ ନା ନାହିଁ?
my humble submission before
ଆପଣ
the
କାହିଁ ସେ why you are raking up the issue of who will be appearing as witness and who will be tendering evidence?
no my lords, they have
that is a matter where you will control there in the trial।
what happened, I am constrained to say because they have given evidence of brother। my humble submission before the honorable court, let the brother be adduced the evidence on a single date।
how can I direct brother
my humble submission
ସେଇଥିପାଇଁ ମୁଁ ହେଇ ବି ପାରିବିନି, ମୋ ଫ୍ୟାମିଲି ଯଦି ଚାହିଁଲେ ବି ହେଇପାରିବିନି।
No,
ଆପଣ ଯୋଉ ମତେ
the
ଫିଲିଂ
sole
ଦଉଛନ୍ତି
problem,
ମୁଁ
my
ସେଟା
lord.
କରିଦେବି ସେମିତି ହୁଏନି
They are taking adjournments. If they will not
ଆଜ୍ଞା
be,
ସେଥିପାଇଁ ତ କୁହାହେଲା ତାଙ୍କୁ ଆଫିଡେଭିଟ ଦେବେ ଆପିୟର
my lord,
କରିବେ ଆଫିଡେଭିଟ ଦେବେ
they may be directed to adduce any evidence in a one day. ଗୋଟେ ଡେଟ୍ ସାର୍ ତାଙ୍କୁ ଦିଆଯାଉ ସେଇଦିନ ଯେତେଟା
ଆପଣ
ଏଭିଡେନ୍ସ ଦେବା କଥା ଦିଅନ୍ତୁ।
ସେଇଟା ଆପଣ ଯଦି ଟିକେ ଆଉ ଟିକେ ପଢାପଢି କରିବେ ଜାଣିଯିବେ ସେମିତି ଡାଇରେକ୍ସନ ହାଇକୋର୍ଟର ଜୁରିସଡିକ୍ସନ ନାହିଁ ପଢନ୍ତୁ ଆହ୍ଲାବାଦ ବାର ଆସୋସିଏସନ ଆପଣ ଯୋଉଗୁଡାକ ଆବସର୍ଡ ସବମିଶନ କରୁନାହାନ୍ତି ମୋର ଯେତିକି ବୁଦ୍ଧି ଅଛି ବା ଯେତିକି ବୁଝିବାର ଶକ୍ତି ଅଛି ଆବସର୍ଡ ଡାଇରେକ୍ସନ ମୁଁ ଦେବିନି ଗୋଟେ ଏଭିଡେନ୍ସ ଦେବେ ଅଧା ଦିନ ଦେବେ ଚାରିଟା ୱିଟନେସ ଆଣିବେ that is beyond the purview of this adjudication.
What happened? Already they have taken 10 years.
This court is not supposed to control.
Simple, they remain silent for 2 years. Now, at the time of argument, they have come before your lordship to give them chances. That is the sole.
ଆଜ୍ଞା ଆପଣ 13 ପଢିଲା ପରେ କାହିଁକି ଆପଣ ଆଉ କିଛି କହିଲେନି ଚୁପ୍ ହେଇଗଲେ
ମୁଁ କହିବାକୁ ବାଧ୍ୟ ହଉଛି 2 ବର୍ଷ ସେମାନେ ଚୁପ୍
କାହିଁ କହୁଛନ୍ତି ଆଜ୍ଞା କାହିଁ କହିଲେ ଆମେ ମୁଁ କରିପାରିବି କଣ ଆଜ୍ଞା ମୁଁ ଟ୍ରାଏଲ କରିପାରିବିନି I cannot control and direct the trial. ଆପଣଙ୍କର କଣ କାହାକୁ ୱିଟନେସ୍ ଅବଜେକ୍ଟ କରିବେ
ଚାଲିବ ଏମିତି ତ ସେ ଆଡଜର୍ନମେଣ୍ଟ ନେଇ ଚାଲିବେ
କେମିତି ଚାଲିବ ଆଜ୍ଞା ଆଚ୍ଛା ଆପଣ ଉଲ୍ଟା ବୁଝିଲେ ଆପଣ ତାଙ୍କୁ କୁହାଗଲା ଆଫିଡେଭିଟ ଦେବା ପାଇଁ ସେ ଆପିୟର କରିବେ ସବୁଦିନ ଆପଣ କହିଲେ ଏମିତି ଚାଲିବ ତାଙ୍କୁ କୁହାଗଲା କି ଆଡଜର୍ନମେଣ୍ଟ ଦେବା ପାଇଁ ଆଫିଡେଭିଟ ଦେବେ
ନାଇଁ ନାଇଁ ମୁଁ ମୋର
ସୋ ଠିକ ଅଛି ଆପଣଙ୍କର କଣ କ୍ଲାଏଣ୍ଟ ଅଛନ୍ତି ଏଥିରେ ପ୍ରେଜେଣ୍ଟ ଅଛନ୍ତି କୋର୍ଟରେ ନା କଣ
ନାଇଁ ସାର୍
ଟିଭି ନାହାନ୍ତି ଆଉ ଆମେ ତ ଆଲାଉ କରୁନୁ ୟୁଟ୍ୟୁବ ରେ ପାର୍ଟିସିପେଟ କରିବା ପାଇଁ
I am constrained because since last 10 years I am suffering 19 cases against me. My wife has lost 19 criminal cases against me. Since 10 years I am suffering. That's sole problem.
ଗୋଟେ କମ୍ପିଟିସନ ଚାଲିଛି ଆମର 37 ଅଛି ଆପଣଙ୍କର ବଢିବ ସୋ ଲେଟ୍ ଅସ୍ ଲିଭ୍ ଇଟ୍ देयर ଆପଣ ସର୍ वी आर जस्ट वेस्टिंग आवर टाइम ଆପଣ ଆଫିଡେଭିଟ ଦେବେ ଆଜି କାଲି ଆସିବ Mr. Chotrae. Affidavit diyor. Mr. Rituranjan Chotrae for the petitioner, Mr. Ellen Patnaik, Lakshminarayan Patnaik for the opposite party. The petitioner is the respondent before the learned judge family court in CP number 23 of 2019.
Yes, sir.
So before by filing the present application, the petitioner challenges the order dated 13/3/2026 ହେଲା passed by the learned judge family court
sir
ହେଲା
lords they have challenged the order dated 29th April
for
29th April order they have challenged
who set aside 13/3/2026
29th April they have passed the order
13/3 ରେ ମାନେ ବନ୍ଦ ହେଇଗଲା ତେଣୁ ସେଟାକୁ ଆମେ
29/4/2026 the said order is reproduced here supporting the order challenging the order it is submitted by the learned counsel for the petitioner that the petitioner is would be prejudiced if एमती लिखिए 29/4/2026 by which the petition dated 8/12/2025 filed by the respondent as present petitioner was rejected.
Let's see 21/4 let's see
କିଛି ପଢିବେନି ଯଦି ଜଜ ପଢିବେ ତାଙ୍କୁ ପଢିବାକୁ ଦେବେନି
ନା 21/4 ରେ ଆମେ ପିଟିସନ ଦେଇଥିଲୁ ଏଟାକୁ 8/12 ର ପୂର୍ବ ପିଟିସନ ଆହୁରି ଥିଲା 21/4 ରେ ଆମେ ପିଟିସନ ଦେଇଥିଲୁ ଟୁ ସେଟା ସାଇଡ କରିବା ପାଇଁ 21/4 ର 29/4 ରେ ଅର୍ଡର ହେଲା
ଆଜ୍ଞା ଦିଟେ ଜାଗା ଆପଣ ଦେଇଥିଲେ 8/12 ଆଉ 20/21/4 ଗୋଟେ ପିଟିସନ
8/12 ରେ ଆଜ୍ଞା 8/12 ରେ ରିକଲ ପାଇଁ ଆଉ ଗୋଟେ ଅର୍ଡର ହେଟା ଅଲଗା ପିଟିସନ ଥିଲା ହେଟା ପେଣ୍ଡିଂ ଥିଲା ତାଙ୍କ ପାଖରେ
sir that was disposed of ସବୁ
ସରି ଟିକେ ପଢନ୍ତୁ sir पेज 23 ପଢନ୍ତୁ ଆଜି ଗୋଟେ ମ୍ୟାଟର ରେ ଗଲା ପୁରା ଟାଇମ
ଆଜ୍ଞା
the case record is put up today for order
order on the petition dated 8/12/25 and 21/4/26 8/12/25 ରୁ ଗୋଟେ ପିଟିସନ ଥିଲା ଏଟା ପେଣ୍ଡିଂ
ସो ତାପରେ ଟିକେ ପଢନ୍ତୁ पेज 24 କୁ ଯାଆନ୍ତୁ
ଆଜ୍ଞା on behalf of the petitioner praying to issue summons in favor of Padma Charan
पिता नेक्स्ट पेज टा पढନ୍ତୁ praying to issue summons नेक्स्ट पेज पढନ୍ତୁ कोन लेखा हैछि
Next page. So, so far,
Thus the petition,
hence the petition present, I am inclined to recall the petition.
ଏଠି ତ ପଢୁନାହାନ୍ତି ବି।
Thus the petition 8/12/2025 stand rejected.
ଆଉ ମୁଁ କଣ ଭୁଲ ଡାକିଲି?
ଆଜ୍ଞା ଆଜ୍ଞା 8/12/25 ଟା ରିଜେକ୍ଟ ହେଲା ଆଉ ପୁଣି 21
କୋଉ ଦିନ ହେଲା? କଣ ହେଲା?
29 ରେ ଆଜ୍ଞା।
ଆଜ୍ଞା ଦେଖନ୍ତୁ ଆମେ କିଛି କଲେନି, just simply spent our time, sir।
ଦିଟା ରିଜେକ୍ଟ ହେଇଛି ଆଜ୍ଞା ସରି
ମୋର ଆଜ୍ଞା ବିଲକୁଲ ଅଭ୍ୟାସ ନାହିଁ ନ ପଢିବାର, so what can I do?
ଦୁଇଟା ରିଜେକ୍ଟ
କଣ ଲେଖିଲେ?
The petition dated Act 1 for respondent
And the petition dated respondent present petitioner and the petition dated 21/4/26 were rejected. The petition dated 21/4/26 was for recall of the order dated 13/3/2024. The order dated 13/3/2024 is reproduced here. ଆପଣ ଟେକ୍ନିକାଲି 13/3 ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବା କଥା ଥିଲା। Though that Mr. Patnaik has not argued that, ଆପଣ both order you should have challenged. Because without challenging 13/3, how it will be recorded? Only was recorded. 13/3 reproduce कर देले पर the lauded judge as से order टा आपण ऊपर करचंती reproduce करचंती order टा ने 29 टा करचंती हां सर 29 बता 13/3 टा कर देले पर it would be evident from the order dated 29/4/2026 that the respondent was given 26 adjournments and her evidence was closed on 13/3/2026. After 2 years, hence the court was not inclined to recall the order dated 13/3/2026. It is further submitted by Mr. Chotray that the order dated 28/2/2024 does not reflect the fact that evidence of the respondent, as present petitioner, was not closed. Stop. Objecting the prayer made in the present writ application, the learned counsel, Mr. Ellen Patnaik, for the opposite party submits that the order passed by the learned judge family court is just and proper and needs no interference. He submits that the petitioner, the respondent present petitioner has been granted sufficient time. For no reason, the litigation is dragged and his client, the respondent, plaintiff. See, plaintiff ne petitioner da kon na dichuntan. Respondent petitioner before the present opposite party dash petitioner before the learned judge family court is put to harassment. Stop. Having had learned counsel for the parties, in considered opinion of this court, in the interest of justice, the present petitioner dash respondent before the learned judge family court should be given another chance, for which she is required to file affidavit before this court, indicating that she shall appear on the date as directed by the learned judge family court and shall adduce and shall know and the evidence on her behalf. About Mr. Patnaik, your point is also taken care. Evidence on her behalf kar deli. Satisfied tha? And evidence on her behalf shall be completed if required on consecutive dates without fail, without granting adjournment. Stop. The affidavit aji debe to?
Tomorrow, Your Lordship.
Acha, the affidavit shall be filed in court. The matter shall be listed to marked as to be mentioned tomorrow. Hala? Kali asio to be mentioned hi.
Obligement.
Now the actually rest of the matters 13 to 19, whatever is left out, fresh matter will be added to tomorrow's list.
Pardon, my lord. Item
Please.
78.
TK, sunantu. Now the time is over.
My lord.
The problem is that somehow it takes time, as you notice.
My lord, item 28.
Ruhନ୍ତୁ sir. Let us go page. आपनकर 13 to 19 जेतिके रहिला left out matter रहिला अर्जन हेनी add हेगला काली पई fresh रे. तापरे 20 रु ऑर्डर्स गुडाक काली पई के आपण काली पई लिस्ट करछन कि ठीक अछि काली ऑर्डर 20 रु 26 जहा लेफ्ट आउट रहिला add हेगला.
Item 28.
22 टा
सर शुणନ୍ତୁ 22 adjournment चाहउछंती कि
आज्ञा से छुट्टी परे आसीत तो
अरे अदर साइड कहांती कोन सेटा आपनकर लिस्ट हेछि ना
नाहाती आसी ना
आ सेटा को आपण ताको प्रेजेंट से करबा कथा ना
ना ठीक अछि
काली आसु काली कर देबे
Item
करो तो काली कर दे मिस्टर दास
28 will be common tomorrow, my lord.
28 नो आज्ञा सुनु ना आपण को मु कहली जे अप टू जेति रहिला अप टू फ्रेश एडमिशन ऑर्डर सोची 26 रे लिस्ट देखो न टिके तो 26 पर्यंत जहा जेति रहिची ऑर्डर हेइनी काली आसिला बाकी आफ्टर नोटिस जहा रहिला ताकू आफ्टर वेकेशन कर दियंतु
Say that that's actually my date may be fixed because I am not entitled to get the provident from
आपण 27 रे की डेट 27 की मेंशन करथले की डेट करछन बोधे
because
26 माइल
28 मिस्टर
28 my lord, Mr. kindly taken up in reopening so that it can be because
ठीक अछि 28 डेट करू जल्दी करू टाइम हे गेला यार
29 वो काम
29
deep development
तापरे 29 रु 37 मिस्टर संजीव चक्रवर्ती
21 टा थिला रिपोर्टटा जज फैमिली कोर्ट करो
काली तो आछी हो
काली रही भी नहीं छुट्टी पर आछले
के का रिक्वेस्ट करंतु मैडम सिन्हा को का करंतु
मैडम को दियो करो बात करी आनी
हां काली रखंतु काना ऑलरेडी सिंस आई हैव क्लोज द
छुट्टी पर आछलो कर से रिपोर्ट दे दीजन छुट्टी पर आछो इंटरव्यू
काली कर देबी आई विल पास दैट ऑर्डर
अदर साइड भी अच्छा आई एम फॉर दी छुट्टी पर दीजन ना कहू
सर 21 टा आसीबो छुट्टी परे
आगे यस
से जो आपनकर पैसा दोचंती आपण से अवेलेबल वारंटी छि एनबीडब्ल्यू छि 21 टा को छुट्टी परे कर दियंतु एंट्री मॉडल को कट 6-7 मिस्टर सर मिस्टर तपस्विनी सिन्हा फॉर द पिटिशनर मिस्टर पीसी दास
यस
21 ठीक मार दियंतु ताको एक्सटेंड कर नाउ आइटम 27 29 की मेंस कहले 30 31 32 33 34 35 36 37 मिस्टर वर्मा आइटम 15 टुमारो
माय लॉर्ड टुमारो माय लॉर्ड
ठीक है जोड़ा लेफ्ट आउट रहला सर फ्रेश एडमिशन ऑर्डर से काली कार्ड हेगला
माय लॉर्ड
यस
हाईली प्लेस्ड
मनोरंजन मिश्र
आया 37 आ गया 37
सर कौन करियो एटा
आगे
कौन करिबा कोंतु आफ्टर वेकेशन ना काली की
कवर्ड मैटर द डिसीजन ऑफ दिस आर नो छोटिया मैटरटा आया से
मैडम नहीं जानी भी आफ्टर नोटिस मैटर ना एब्सेंस से तो करी होगा
काली आसो
काली रखो 34 ठीक है
आगे
तब पेज 6 रे 38 रु 41 के कोन कहउचंती ओके बाकी रेस्ट गुडा को आफ्टर नोटिस आपण डेट करिवे डिलिस्ट करिवे ने डेट कर देबे हेले जेति की रहिला के नाहंती सो
item 26 माइल
26
हां माइल 26 ऑर्डर मैटर
26 टा सर काली को अछि रहिला सर
ना अमेंडमेंट पिटिशन
रहू मु तो देखो आई कैनॉट पिक अप मैटर्स आज काली आसीओ काली आउथरे ऑर्डर
Item 19, my lord, may taken up on tomorrow. Item 19.
डेफिनेटली आपनकर अप टू 26 सबुडाक टुमोरो हिची
Obliged.
यस यस मिस्टर बेरा प्रभु एंड मिस्टर अंशुमान
No, we are just noting.